Hello, hello, hello. Good morning, good afternoon, good evening, wherever you're watching from. My name is Alfred Amuzu, and welcome to the Ghana Agenda for June 8th, 2024. Today we are discussing the Attorney General of Ghana and some issues that came up in the case of the Republic versus Dr. Ato Forson, Sylvester Animena, and Richard Jakpa. Of course, we know Sylvester Animena case has been sort of closed because for whatever reason he was let go. I believe he had some health issues, etc. So his case is moot, is taken out, is no longer being prosecuted. So the two accused persons, applicants, as we call them in some instances, would remain Dr. Ato Forson, who used to be the Deputy Finance Minister of Ghana, and Richard Jakpa, who was a businessman then representing, in other words, procuring ambulances for Ghana. So I'll go over, exactly what this case is about so we can get some of the facts established before we go into the discussions. I'll also go over the charges, but the reason we are here today, the main reason we are here today, is that an interlocutory application has been filed, which means while a main trial is going on, an application was raised concerning the order of cross-examination, or the order of examination of accused person number 3, which is Richard Jakpa, on the 21st of May. And that application is pending a ruling. And so, other matters crop up after that. And so that application itself is an interlocutory application, but other matters crop up. And then the subsequent application is now being filed that while all these other matters are, being deliberated, that the judge should put on hold the proceedings so that those matters could be settled before going into the substantive, trial itself, to which the judge refused. And we'll go into the reasons why the judge refused. There were other matters such as, a mistrial application, which is saying that based on other evidence that came out since the case started, that the interests of the accused could not be fairly represented, or in other words, the accused may not have a fair trial. As a result, there should be a mistrial. So the judge also issued a ruling based on the mistrial part of it. And then there is another application. So 3 applications we are dealing with. There's a third application which was asking for, and I see Lifetime Legacy, I think I will bring you in a minute. There's a third application which bordered on the conduct of the prosecutor, the conduct of the Attorney General in this particular matter. Here, the Attorney General was heard over a communication he had exchanged with accused number 3, where he was heard making some pronouncements, like, if you could procure an excuse duty to avoid court because the Attorney General will be traveling, and on some substantive evidentiary issues as to how the accused number 3 should testify in court, and people think that is witness tampering. And if it is witness tampering, does it rise up to where the trial should be treated as mistrial? And so what constitutes mistrial will be one of the issues that we canvass for you today. I am joined currently by Lifetime Legacy. Lifetime Legacy, welcome to the show. It's been a while. Lifetime, can you hear me? Okay, for whatever reason I cannot hear you, but keep going. I'll fix my audio and hear you. So keep going. Lifetime, say something so I can see if you can hear me. All right, we'll be right back. We'll take a quick minute. All right, Lifetime Legacy, please indicate if you can hear my voice. Can you hear me? I think you are frozen. All right, so while we wait for Lifetime to fix his video and come back in, matter of fact, I'm gonna kick him out and then have him come back in. So while we wait for that, let's go over some of what is in the case. And please share the link. I'm sharing mine now. Please share the link so that others can also join us. So we can have a good show. Today is actually going to be interesting because we are not going to rush through this. We'll take our time and go through one after the other, the issues that have been identified in the various applications and the ruling for each of those applications. So stick with us. It's going to be a long show, but it will be very informative. Lifetime, please indicate if you can hear my voice so I can see how things are going on your end. No? So yeah, we're having a little bit of technical issues today, but we'll clear those up and continue the show. Okay, so my boss is fixing his mic, and we'll see how. So I'm sharing my links in the first place. That way, those of you who would like to join us can join, and your contributions and all. All right. Let me see. Lifetime, can you hear me? Nope. Still now. All right. Let's go into the issues. So as I was saying, this ruling was actually on two applications. The first one is that an application for stay of proceedings pending appeal filed on the 21st of May 2024. And what we mean by that is on 21st May 2024, an application was filed, and the import of that application was that okay, let me see. I think my guy is coming back in. All right, Afa Ameyo, thanks for joining the show. Can you hear me, Afa?
Yeah, loud and clear.
Yeah, perfect. I can hear your voice. Lifetime was struggling to join. Okay, so Afa, I was just actually starting. I wanted to go through issue by issue what has been discussed in this ruling. And the ruling I'm referring to is this interlocutory ruling that came down in the case of Dr. Ato Forson, the Republic versus Dr. Ato Forson, Sylvester Animena, and Richard Jakpa. Two applications were actually ruled on. And the first one is an application for stay of proceedings pending appeal filed on the 21st. So on the 21st, an appeal was filed that the order of examination that was ordered, that was sanctioned by the court. So the court had agreed that, you know, there's a specific way that accused number 3 should be examined, which is that the accused number 3's counsel would, you know, first of all, do a direct examination of them. So the counsel for A3 would do a direct examination of A3. After that, the counsel for, okay, Lifetime is coming back in. Okay, Lifetime, can you hear me now?
You are on camera.
Okay, Lifetime, we can hear your
Lifetime,
audio.
we can hear you. We can hear
if you can fix the audio and come back in, Just check your audio, Lifetime. Okay, so as I was saying, so A3's counsel will do a direct examination of A3, which means call the witness, introduce the witness, and have direct questions, right? And after that, A1's counsel was to go and do a cross-examination of the counsel. And this is based on the Evidence Act. I think that's the NRC, I believe it's section 71 of the Evidence Act. And an application was filed by A1's lawyer stating that the prosecution should go after the witness is introduced by his own lawyer. So once A3's counsel do a direct examination of A3, that the prosecution should go before A1's counsel will come. So just the order of examination is what that first application was on. And when that happened, you expect another application to follow to say, by the way, stay proceedings or hold the main proceedings until we have a determination of this interlocutory application. And that is based on the discretion of the court. The court may allow or reject that. So that is the first application the court ruled on. The court rejected that. The second one is a motion or notice for an order of inquiry into the conduct of the Attorney General, which is the fact that the Attorney General was heard on tape, as we've discussed last week, sort of instructing the accused person to procure leave or excuse for leave of court so that the Attorney General, could complete a trip he has, which we thought, is inappropriate to do. He couldn't be contacting an accused or witness in a live case, a case that is in court, in front of the court to which he is a party. He could not do that. No lawyer can do that. Should be against the rules of the legal profession. So that is, one of the motions in the second application. So the second application have a couple of motions. So the court ruled on that as well. The second motion in that application is an order of mistrial in the instant criminal proceeding. In other words, they are saying because of the matters that came up in that tape that the accused persons may not have a fair trial. So they are asking for a mistrial. The court made pronouncement on that. An order of jurisdiction to restrain the prosecution from any further prosecution of the instant criminal proceedings pending the determination of the applicant's motion for mistrial, and or an order of stay proceeding in the instant proceeding pending the applicant's motion for mistrial pursuant to Article 12.1, 19.1, 2, and C and E 33. 188.1 and 4 of the 1992 Constitution. So basically, the last two there is just saying that, they want a mistrial. Why do they want a mistrial? They want a mistrial because, we talked about the mistrial, but they want a mistrial because of the matters that came up on the tape. Secondly, they want the prosecutions to stop prosecuting the accused persons until the determination is made on the mistrial, and a determination has been made on the mistrial in this ruling. So we'll take that as well. And also, the second one too is just that because of the pending applications that if a stay of proceeding is not entered, that it would abuse the human rights provisions of our constitution that is allowed to any accused person, and that will be captured in Article 12.1, 19, 33, and all those other articles they reference. So, Afa, you've read this. The way I want us to do this thing is I want us to take it one application or one ruling after the other. The judge analogized a couple of cases in her ruling. I want us to take the ruling itself, the cases she analogized, and and then kind of attempt to do some analysis on our own to say, has these judgments been clearly and properly delivered based on our understanding, our lay understanding, right? We are not the judge. We are not in her capacity. She has experience, of course, but we still want to look at, the proprietariness of some of the pronouncements in those judgments. So I'm going to go first to you to kind of get your general characterization, where you stand with regards to reading this ruling and where the case is, just briefly, because we are going to go into the substance. So I don't want you to right off get into the substance. Just give me general disposition after reading the entire ruling so I know where you stand. And then as we go into the individual applications and how they've been adjudicated or what ruling was given for each application and the reasons given, we can go into the substance at that point. So for now, what is your general demeanor? How do you feel about reading the ruling that has been issued? Do you, in your mind, agree with the ruling, or do you think perhaps the judge could have done more or could have not, made pronouncements on other things because they may not be necessary from your understanding or from what you read?
Yeah, thank you very much, Amuzu, and thanks for the opportunity to come here and help contribute towards the discussion. I think it's all part of couching a pathway that is fair, that is equitable, contribute our quota by way of discussing towards the development of the country. Yeah. Why are we here? We are here because somebody has been accused of having gone to make purchases and that it has breached what was laid out in the contract, and that money has been lost to the state for which somebody ought to be accountable.
Right.
So in the course of the trial, things have come up, and then the court is called to deal with. These are normal. We call trial within a trial, right? And stuff like that. So these are basic stuff that comes with the legal procedure and adjudication of cases up to the end. So the judge has given her ruling on what transpired, and what is my take on it. I agree with all that he said, including the advice to the attorney general. I agree completely with everything.
I wasn't
And I
I wasn't expecting any difference, but that's good. Okay.
and particularly with the
Mhm.
choice of words. I think that after the ruling, the attorney general had to seek clarification whether it is to get, is it an order, a directive, or is it just an advice, and then that was clarified. So I
Okay,
agree with
so
it. The
what if I'm referring to there, just for clarification, for those who may not have read the ruling, is that towards the end, I believe the last page, which is on the page 39, the judge had advised, in her opinion, she advised the attorney general to prudently say it will be prudent for the attorney general to excuse himself from any further prosecution of the case. Um, and her reasoning was that doing so would protect the legal system. So that's what you mean by you agree with that as well.
Yes,
That's what
I
you said you
agree
agree
with the
with. Okay.
advice, and it came as an
Mhm.
advice and not an order.
Right.
Sometimes when you're doing something and somebody think that there is a better way of doing it, or something is not this, and the person can advise you. It is different from being ordered. Being ordered, you mean we've come to the conclusion where you are within my remit, and therefore I have to tell you, so that when something happens, you will be it will know, you will be in a position to know that you were ordered to do it and stuff like that. Now, you see, so you said we're going to go into the substantive. For me,
Yes.
all these things are, somebody will say, um, you know, there is no need for this or that. It is important that in the court of law, that whatever you feel needs to be added, needs to be addressed, that they are addressed. Because at the end of the day, this is a criminal matter. Either somebody will be, the result is somebody will be put in jail, you'll be made to pay something, or your rights will be breached some way, one way or the other. So it is important. Nothing, absolutely nothing. We all need to be clear in our mind that I sorted, I challenged this, I did this, and I did that, and then at the end of the day, this is what the result is, so that we all will be on the same page when finally a judgment is delivered, right? And one good thing about the court system is that they are layers. It is not a cut in stone that after this, there is nothing you can do. You always have, it is only at the Supreme Court that once, even at the Supreme Court, if it has given its ruling, you can still go for a review, to finalize whatever will be said. So, if there is something that is not good within our judicial system or, whatever it is, let's just fix it. But, my preliminary comments will be that, yeah, I agree completely with whatever the judge said. And if any of the parties feels that something is not right, take it to the next level. And then we go away we go from there.
Okay.
Other than that, it will be you say this, that one say that, and then we are caught in the middle. But there has to be somebody who will settle the score, whether we like it or not. And then you go through the process and we get clarity on that. Thank you.
Okay, so let me go over just quickly what the main issues are, and then we'll take them issue one at a time, right? One issue at a time. So the judge says the main issues to be determined are one, the matter was settled that the ambulances in the states that they were delivered. The ambulances in the states that they were delivered could not serve any useful purpose, but the assertion was made per the cross-examination and other evidence put forward, particularly by the third accused person, also referred to as A3, that there were moves to fix the defects, thereby buffering the case that there was no loss occasion to the state. Would explain that a little bit, right? So basically what is happening here is that this whole case is coming as a result of ambulances that were procured around 2014, 2016 timeframe. The ambulances came to Ghana, but they were not equipped to function as an ambulance. So basically, the court is saying, the accusation from the prosecution is that there's a financial loss to the state because you procure ambulances that are not useful to the state. And here, the issue being laid down for determination is that, yes, both parties agree that the state in which those ambulances were delivered, they could not serve any useful purposes. But accused number 3 proffered the defense that those ambulances had defects that were known, and those defects were going to be cured. In other words, the ambulances didn't have the equipment in them to make them an ambulance. It was just those vehicles, but that they had procured those equipment that were going to be installed in the ambulance separately. Okay, so that's one. So what this means is that the circumstances that the persons against whom the charges have been laid would have a prima facie case to answer. So because of the fact that it is agreed that the ambulances that came into the country were not useful, there is a prima facie case. If you say the ambulances you brought, yes, had defects, but you were working on remedying those defects or curing those defects, there is a case because you brought an ambulance that we think is not useful. You said it is going to be useful, so prove to us. Other than that, there wouldn't be a prima facie case. A prima facie case is established here because there's a dispute over the usefulness of the ambulance or whatever is going to be done to it to make it useful. So there was a case to be answered. And if there's a case to be answered, you open your defense. The second aspect of that is further, there was the issue of whether so there's the issue of what authority A1. I think your audio is coming in.
Is it my audio? Is it from me?
Yeah, if you can mute your audio as you wait. Okay, so good. It's clear now. So he's saying that further that there was the issue of what authority A1, which is Ato Forson, what authority he exercised when he asked for the letter of credit to be issued. It is the case of the prosecution that the letter of credits were issued without due cause and authorization. The prosecution, in stating that A1 had no authority, has stated, among other things, that the agreement that culminated in the delivery of the defective ambulances, which cannot be used in the condition that it is. So on the part of A1, he insisted that he had the authority of the Minister of Finance, whose deputy he was, to issue the request. He was then called upon to put forward evidence of this authority, which he has done. and close his case. As indicated, A3 is in the process of testifying and is being cross-examined and has indicated that he has other witnesses to call. So then we'll go into the duty of the court. So the duty of the court says it's left for the court to complete the hearing, assess the evidence when the hearing is concluded, and deliver a judgment, keeping in mind the charges and nothing extraneous before it. So the court is, of course, not going to listen to all the political commentary we are doing. They're just going to concentrate on the evidence before them and make a judgment. Afa, it seems you went out briefly, so I'm bringing you back in. Basically, those two things, right?
Yeah.
One, the ambulances actually, the power of ambulances, which would not be a useful state established the case. Second, the question of authorization, which, the deputy minister was, exercising, and I believe the deputy minister claims he has authorization. The state think he doesn't have authorization. So there's a clear dispute. And if there's a dispute, we have an issue that need to be adjudicated. So those two things actually help establish a prima facie for which they are supposed to open their defense, and they've opened their defense. Now, the second aspect, which requires authorization for the letter of credit. Remember, this whole tape that has come into evidence dealt with that letter of credit, how it was procured. The letter of credit was supposed, according to everything we've heard and everything we've read, the letter of credit was supposed to give the guarantee to the company shipping the ambulances to Ghana that if you ship ambulances to Ghana with the equipment, etc., that you will be paid. And there's a condition precedent in that letter of credit that says, upon sighting or whatever we call pre-shipment.
Upon delivery.
Not delivery. Upon sighting. The word you use in the contract
Okay,
is
yeah. Okay, so
sighting.
the word is sighting. Now, what is sighting?
Right. And so the dispute really on that tape that we heard is the Attorney General's belief is sighting should be delivery.
Yeah.
Whereas Jakpa's belief is
sighting means
should be
bill of lading.
No, bill of lading including pre-delivery inspection, right?
Yeah.
So pre-shipment inspection. So
pre-shipment inspection. Okay.
Inspection. So those pre-shipment inspections were conducted from the standpoint of A3 Jakpa, that the letter of credit was established then, since the pre-inspections were done and sent to the bank, and the bank will honor it upon the shipments and the addition of the bill of lading. And that was exactly what Jakpa thinks happened, or Jakpa thought happened, or Jakpa observed from being a party to this contract. Now, the Attorney General's belief is different from what Jakpa knows to be the fact. He thinks, or his assertion is that there was no authority to establish a letter of credit until, there's a delivery, or until the delivery of the ambulances. So that again goes to the heart of the matter, right? If in fact delivery wasn't necessary for letter of credit to be established, then the question of whether someone has authority, right? Whether somebody has authority to enter into a letter of credit is moot. So you couldn't bring a case against me for lack of authority to enter into a letter of credit if it is established that the condition precedent is citing only, which requires citing pre-shipping, or what Jakpa was describing on that tape. So I'm bringing this up so that we can have a good appreciation of how the facts would play a role in the tape, and whether the tape is important, and if it goes to the heart of, if the tape is important enough that it goes to the heart of the matter, should the matter be set aside, or should, subsequent, how should that tape be used? Because the judge used it in a way here that, I personally don't agree with. But let me go into the first issue and then take your opinion on how she dealt with the first issue here. So the first legal framework. So she established a framework, legal framework, talking about jurisdiction, because this thing actually is questioning the jurisdiction of the court. Does the court have the power to set aside a motion or applications, to set aside the proceedings while a motion application is being is pending determination, and a few other ones. So it says on the application sought to order an inquiry. So let me take the first one. It says jurisdiction in criminal matters cannot be implied, and she says, one, on the application sought to order an inquiry into the order of the Attorney General's conduct, the court has been invited to order an inquiry into the alleged witness tampering by the Attorney General. Unfortunately, there's no rule of law or practice which allows such an inquiry to be remade in the course of criminal proceedings as this court is being invited to do, particularly when the alleged misconduct did not take place in the view of the court or in the hearing of the courts. So that's her issue, that there's no precedence, especially when the matter is not done, the issue is not, or what the inquiry is about is not something that was done in the view of the court or in the hearing of the court. Second, Papa, are you there? I want to be seeing your face while I'm telling you all this.
Yeah, I'm here. I'm listening. I'm looking for the.
But
I open it myself.
Okay, if you can have yourself on the mute though, because I'm still getting the feed.
Yeah, okay.
And then he said it must be borne in mind that the A3, which is Jakpa, is still being cross-examined and made an allegation against the person of Attorney General in a bid as cross-examination is meant to do to undermine the case of the prosecution. So in other words, Jakpa is still under cross-examination, and when you are in a cross-examination in a case in which you're a witness, the bid is so that you can undermine the prosecution's case. That's what she's saying there. He said the prosecution is yet to commence cross-examination. Even A1 himself is yet to conclude the cross-examination of A3, thus describing what has been put forward as uncontested or unassailable is not a proper statement of law of evidence. Is it the case that there should be enough to cause the court to make an order for an inquiry? And what statute or rule of proceedings? So she's asking us a most of questions, and her answer is there is no such provision. What jurisdiction is to be exercised must necessarily be within a certain legal framework, and this is without prejudice to whatever administrative steps may be taken by the appropriate body in respect of the allegations raised. To conclude, under this head, I hold that there's no legal basis for court in the course of criminal proceedings to order an inquiry into the conduct of a prosecutor. There must be another forum for such an exercise, but this criminal proceedings cannot accommodate it. And here, I think the Attorney General, the courts perhaps didn't get it right, but I'll take your opinion on that. Afam, what do you think? The court is saying that there's no law, there's no rule that an inquiry be opened into the conduct of a prosecutor while a case is going, especially on a criminal case like this. There's nowhere in Ghana's laws that should happen. Now, why I have problem with this is that he shouldn't do any proper. There's not any analysis really of why that is. So she's saying there's no statute, there's no law, therefore it can be done. But along the way, we will see that she went to Canada and she went to other places and pulled some laws and cases and analyzed them, and then say there's no analogous, there's no statute that kind of models those Canadian laws, and therefore she couldn't make a decision based on a non-existing statute in Ghana. Therefore, she's ruling that we can inquire into the prosecutor's conduct while a case is going on. There's other forums for that, and that forum could be the General Legal Council or other places. And let me just give the caveat that the law is regulated by lawyers, right? There's no law for lawyers per se. The law that regulates the conduct of lawyers is usually crafted by the lawyers themselves, or in other words, the General Legal Council becomes who does that. In the United States, we call those the model rules of professional conduct. In Ghana, they call it lawyers' conduct and etiquette. So when a lawyer is involved in misconduct, you can't sue the lawyer per se. You have to just report him to the Bar Association, and the Bar Association will take care of him. Do you think she's right on this matter?
Absolutely. That's why I say I agree with that. Now, you see, the whole point is that on that basis, you are saying that something has happened. You want that to be investigated, and that the court will grant you the order. I have never seen anybody go to court to do these things. There are investigative bodies in the country that have the right and these things to establish. We have the, we have the police, we have Ioko, we have Shraj, we have, the special prosecutor, depending on what the whatever is happening or whatever you want to inquire to borders on, So I don't the lawyer, the judge did not say you don't have a case, right? In any case, the judge agreed that there is some kind of something. He used the word discomforting that has happened.
No,
Okay.
the discomforting part, the discomforting part has to deal with the matters that were captured on the tape, right?
No, the whole conversation,
Well,
not the matters, but the whole
well,
conversation. He said it shouldn't have happened in the first place.
yeah. So the conversation captured on the tape. That's what I
Right,
mean.
right,
Okay.
right. So if you want to, it is like, say, a medical person has done something, then you go to court. When they have the Ghana Medical Association or the professional body that necessarily is mandated to deal with this. Now, if it is something that is criminal, then of course, yes, you cite the appropriate law that the thing infringes upon, and then you bring it
Mhm.
in. And let people understand that if somebody has done something wrong, but there is no law to pinpoint and say, based on this law, this is wrong, the person hasn't really done anything wrong. These are basic things in the law. When you go to the court and you say something untoward has happened, okay, quote the appropriate law under which this cannot be done, or this thing that was done shouldn't have been done, or was done wrongly,
Right.
or it's affecting somebody or something of that sort. If you cannot quote, you just go there and kind of, you want to invite and invoke certain whatever. The court doesn't really have time to really delve into conjecturing and stuff like that. So be
Right.
straight, go straight to the point, pinpoint the things. Based on this, I think this and this has happened, for which I need this and that redress and stuff like that. So the court said, okay, I am not. If you think that still it is the court, okay, go to the next level. This is the high court, right? Go to the next level and then we take it out from there. But I think they're referring them to the appropriate forum or the General Legal Council is appropriate. And we've been made aware that there are other several places that they could go and seek redress. For me, these are all theatrics. And then if we eliminate them from, it's just to delay the case. If we
Okay.
eliminate them from it will, but if somebody says they have an issue, you deal with it and then they take it out from there. Yeah. So
Okay.
yeah, I think that they should go to the General Legal Council. In fact, there are a lot of people that are saying, oh, the Attorney General is not subject. No, no, no. Take it. If you think he has done anything, we've got to misconduct. It is the Ghana Bar Association or the General Legal Council, whichever it is. Now, the Attorney General is supposed to be a member of the body, of that council. Okay, if these are all these things have been taken care of, they're not going to go there and then the Attorney General is going to sit on a case that is bothering him. No, 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 no. He would have to recuse himself over there. I mean, the recuser would definitely come in because you cannot be a judge in your own case unless it's a contempt of court, where the court is a judge where the judges are a judge in their own matters and stuff like that. But any other, you recuse yourself and then things okay. So for me, the court of public opinion is divided, right? Everybody is
Mhm.
saying this and that. Go to the appropriate, let there be a pronunciation. Where once the pronouncement comes, we can take it out from there and then we do justice to the matter. Yeah, we can have our conversation, but let's seek the redress and let us get the precedent and then so that we will work on it.
Okay, so
Yeah.
if I'm gonna try to read to you a couple of observations that the court actually went into from cases outside the jurisdiction. They went into Canada, so these are like alternative resolution. Like if Ghana doesn't have laws, I mean we are part of the common law, so other countries may have laws or cases that dealt with similar matters, and perhaps we can adopt from that. Those cases are not binding on us, but they become persuasive, right? We can make a
Right.
case based on them. So the first one they looked at is in other words, I believe is Republic versus O'Connor. This case actually happening. If you are following along, this will be on page 30 of the ruling, um, where it says Justice Dobb, speaking for the anonymous Supreme Court of Canada, established the framework for dealing with situations where the fairness of the trial is compromised, including by witness tampering. He says the court did not grant a stay of proceeding, but instead focused on balancing the right of the accused against the need to maintain integrity of the judicial system. So let's keep that in mind. You have to balance the needs of the accused against the need to maintain integrity of the judicial system. It says that and in that opinion, the judge opined that it seems to me that conducting a prosecution in a manner that contravenes the community's basic sense of decency and fair play, and thereby calls into question the integrity of the system, is also an affront of constitutional magnitude to the rights of the individual accused. So clearly, the judge here in Canada is thinking that if you kind of approach the prosecution in a manner that is not decent or that affronts on basic decency, it infringes the constitutional right of the accused. Notwithstanding, the court took the view that staying the prosecution was not the only option to ensure there was trial fairness. So even though the court in Canada observed that, I mean, you can't tamper with witnesses and not say that the accused person's right will not be affected, but in doing so, the court says you have to look at whether there are other means of resolving that impact on the accused person's rights.
What page are you reading from?
So I'm going from 30. I just finished 30 to 31. So
okay.
The last one I just read is on 31. In the middle of 31, in the italicized, where it says, it seems to me that conducting a prosecution in a manner that contravenes the community's basic sense of decency and fair play, and thereby calls into question the integrity of the system, is also an affront of constitutional magnitude to the rights of the individual accused. So in other words, you are infringing on the constitutional right of the person accused if you tamper with witnesses. But the Canada court did not necessarily stay proceedings because of that, because the Canada court says you have to look at in the weighing of or in the balance of the weights of what is in the interest of the state and the individual. You have to look at whether other means exist for you to ensure trial fairness. So I want us to kind of see whether there were other means that could.
Your audio is off. Your audio is off.
Hello. Hello, can you hear me?
you hear me?
Can you hear me?
You now?
Okay, perfect. Sorry about the audio there. I think my battery just gave up on me. The gods of
Yeah,
the
but
MPP
it looks
are
like
at work.
my screen is not on.
All right. So basically what I was saying is that even
Alfred, can you
in
hear
the
me?
courts of Canada, in the Canadian courts not taking on to stay the proceedings, that was based on the fact that there has to be an optional way of guaranteeing
can you hear
child
me?
fairness, right? They took a second case. The second case is Republic versus Reagan, and that is also on page 31 if you are following along. It says, during the police investigation into an allegation that an accused, a former Premier or Nova Scotia, had committed numerous sexual offenses against a variety of young women who had worked for or with him, a police officer confirmed to a reporter that the accused was under investigation in violation of police policy to remain silent about an individual suspect until charges are laid. At the conclusion of the investigation, a report was submitted to the Director of Public Prosecution requesting his opinion about the laying of charges. The DPP recommended the charges should be laid involving 4 of the 8 Nova Scotia complainants who were willing to testify. He chose the incidents which involved the most serious physical violation. He also recommended that the police recontact the 6 women who had been victims of apparent criminal conduct but were unwilling to testify. The police did not agree with the DPP's charging recommendation, being of the view that a more complete picture of the allegations against the accused persons should be put before the court. After the Crown joined police in re-interviewing most of the original complainants, 19 counts for sex-related offenses were laid against the accused. 1 year after the preliminary inquiry, the Crown decided to prefer a direct indictment setting out 18 counts of sex-related offenses, including 1 new charge. After the DPP's written recommendation, one of the Crown attorneys met with police. At that recorded meeting, she suggested that it would be advisable for charges to be brought before a particular judge because he thought he might be a political appointee of the same party as the accused. Instead, she said she would keep monitoring the court docket to see who is sitting when and what would be in our best interest. Police and Crown also agreed to re-interview a number of the complainants. The case preliminary dealt with prosecutorial misconduct. The court discussed the relevant law on procedural fairness. The Supreme Court reiterated that a stay of proceeding is last resort and should only be granted in the clearest of cases where there is no other remedy to cure the prejudice suffered by the accused. So on and on, this matter of prejudice suffered by the case, by the accused, it's only granted where there's no other remedy in, say, in Canada, for example. But I'm going to just do one last one, and that will hammer the point I'm trying to make, which is the Republic versus Barbados. That one is in 33. It says the accused were charged with numerous firearm offenses as well as offenses related to importation, production, and trafficking of methamphetamine. During the course of the trial, the accused brought an application to stay proceedings for abuse of process. And I think this one is very analogous to what we have in front of us. It says they took issue with 3 forms of state misconduct. One is attempts by the Crown to intimidate them into foregoing their right to a trial by threatening them with additional charges should they choose to plead not guilty. Second is collusion on the part of 2 police officers to mislead the court about the seizure of a firearm. So let's underline that. Collusion on part of 2 police officers to mislead the court about the seizure of firearms. And the third one is an improper means by which the Crown in obtaining the medical records of one of the accused persons without his consent. So the trial just stayed proceedings in this case. The Quebec Court of Appeal set aside the stay and ordered a new trial. Okay, so the trial court stayed the case based on these 3 allegations. One being that they threatened to add additional charges if you don't plead guilty. Second being that there's a collusion by the police officers to mislead the court. Third being that there's an improper means by which they obtain medical records. When that came up, the court the trial court stay the proceedings, no longer continuing the proceedings until they resolve these matters, which is what is being asked for here by accused number 3. The Quebec court, the appeal courts in the case, however, set aside the stay and ordered a new trial. They ordered a new trial when it was appealed. The accused persons appealed the decision of the appeal court, and here's what the Supreme Court said. The Supreme Court dismissed the appeal. The court concluded that the Crown's conduct in securing Mr. Whatever the name is, medical records, occasion no prejudice to the integrity of the judicial system. It continued to say the harm caused by finding of the police collusion was curable through an alternative remedy. Okay? Excluding the firearm from evidence against both appellants was that remedy the court was talking about. And then the third, it says the Crown's threatening conduct, while reprehensible, did not approximate the type of shocking conduct needed to justify a stay. So basically what it means is for a stay to be granted, the conduct has to be shocking, right? And it has to be some extraordinary. Now, even though a stay may not be granted, a good reason for its non-grantion or for the stay not to be granted is that there has to be an alternative remedy. In the case where the police were colluding to deceive the court says the evidence in question should be removed.
Exactly.
Okay, so in this particular case, let me bring it to our particular case now. In our case, we've heard the Attorney General, if for nothing at all, on that call, trying to get the accused number 3 to deceive the courts.
No. Oh, with regards to the medical this thing, right?
Procure medical leave to show that you are not going to be available for court.
But can we stick to the conclusion drawn by the words used by the court instead of ours?
No. I'm saying I get these people. No, I get the words used by the court, but before the court actually got to that conclusion, they had done these cases. They reviewed these cases to give them the rule of law on which they are basing the decision, right? So I've taken time to go through those same cases with you so that we can come to whether the conclusion drawn by the court is actually borne by the rules that they have reviewed. And these are the alternatives. So if you look at the rules they review, the court didn't tell us, like you've done the reading as well, the court didn't tell us they told us alternative remedies, in other words, go to the General Legal Counsel. But in this particular case, where in the Baobab, Republic versus Baobab's case, which is most analogous to our case, where there's a prosecutorial collusion to deceive the court, here there is an attempt to collude with A3 to deceive the court. And when that happened, the remedy the court in Canada actually sided with was elimination of the evidence to which that collusion had impacted, which is the firearms. So in our case, is it fair to ask that the right thing to do, if you were following what law was laid in Canada, would have been to eliminate the evidence that the letter of credit and all these things that were captured on that tape, which was fruit of that collusion, right, should be thrown out? Because if that evidence is thrown out, there are implications. But would you agree that if you were following the law as reviewed in this ruling by the judge, that the judge should have exercised the remedy to eliminate the evidence rather than refer it to General Legal Counsel?
Yeah, thank you very much. That's a very good question. So in this case, you see, the evidence were not from the accused, okay? The evidence, the firearm was put in to make their case better. Now, the letters of credit here is part of the case.
No. What do you mean? So the firearm case in Canada, right? It was a collusion by, you want me to take it, look at it again?
Yeah, but there was no firearm though.
It was a collusion on part of two police officers to mislead the court about the seizure of a firearm.
Which means there was no firearm, right?
No. No, it doesn't mean there's no firearm.
There was a firearm with the accused. How can there be collusion to put in a firearm?
There was a collusion on part of the two police officers to mislead the court about the seizure of a firearm. So the operation is the seizure of it.
So there was
It
no
doesn't mean-
firearm seized.
It doesn't mean there was no firearm in, but it
So what
could
does that mean? What does that statement mean, though?
the seizure of a firearm could mean that the police actually didn't seize a firearm.
Okay.
You understand?
Okay, so let's go with that because we need something definite to understand what that particular thing means.
Right. I mean, this is my frustration with this writing because the judge.
Exactly. Because does it mean there was no firearm and they put it in, or
No.
there was a firearm but it was not seized, and then they said it was seized? You know, so
Well, if I'm reading this, if you read the whole thing, it says the accused were charged with numerous firearm offenses. So it means there was a firearms, right?
Right.
In the case. Now, so the collusion part is just dealing with whether they were seized or not seized.
Okay.
You understand?
Okay.
Because the whole case
but
is
the
about
collusion, so the collusion is illegal. So let's deal with the collusion, whatever, you know. Yeah.
Yeah. So I'm saying that there was a collusion to deceive the court, and I'm analogizing that, I'm comparing that with an attempted collusion here to deceive the courts, which we all heard.
In our case, right? In our case, A3 said the Attorney General was impressing upon him to go a particular direction. Now the question is, what evidence do we have so far in the court that was procured through what the Attorney General said, and nothing was pointed to whatever the Attorney General has submitted so far?
Okay, right? So my only thing,
so in this case, what should the
judge? Would you like for me to respond to that for you, though, so that you can have something to work with? Because in my reading, you are asking what specific evidence has the court is in front of the court today that was procured through perhaps what was discussed on the tape, right? And if you listen to the tape, the tape goes to the heart of the issue, which is the letter of credits, its proprietariness or non-proprietariness, right? And it was the letter of credits. If you look at the counts, which we're going to go into the counts shortly, if you look into the count is saying that, I believe one of the counts says the Deputy Minister of Finance, Ato Forson, at the time of causing a letter of credit to be issued, did not have the authority to issue that letter of credit.
Yes.
Right?
Yes.
If it turns out that, and this is the Attorney General's whole case, that because you didn't have the authority to actually issue that letter of credit, you were causing financial loss to the state, or if that, right, is the main argument the Attorney General has, then anything that shows that, in fact, there was an authority to issue that letter of credit makes the evidence in front of the court with regards to the letter of credit problematic. Does that make sense?
Yeah.
So it points to the specific evidence that is at the heart of
but that will be established. That should be established by the defense later on, not even right now. And they are establishing now.
So, I agree.
Yeah, they will establish it. So if we are dealing with the ruling that has come, okay, the ruling was pointing to a coach, the word they used that was coaching, was trying to impress upon him to implicate A1, right? Okay, so if you say you were doing this and this is my evidence, now we read it and then we match the two, okay? You've made an allegation, you have an evidence, so we match. And then in the opinion of the judge, she said, and I'm going to quote her, I have listened to this 10 times, okay? At no point did the Attorney General make this and that and that. If anything came that was towards it, it was words that came from you and not the Attorney General. You got a point?
I have a little problem with that, but we'll get to that one as well, because I didn't think, I thought this is an evidence that the judge admitted into evidence, right?
So the admission is different. So they admitted it because you see, the judge admitted it because if you read the judgment, right, the Attorney General had not contested and denied that.
Yeah, hold on. What I wanted to point to is different. What I wanted to point to is that, right? The judge admitted that as one of the evidence that she would rely on in making her decision, right?
Exactly. Yeah.
Okay. As to why she's actually discussing that evidence right now in this ruling bothers me, because she didn't need to discuss how many times she heard it and how much weight might be.
It's important because that informs
not here, right here. If she was reaching that, then she should have allowed oral arguments. All right, she didn't allow oral argument on this particular evidence, right? Of course, she's free to just make a ruling on the pleadings, like whatever was pleaded in writing. She can make a ruling on that. But if you're going to make such a thorough analysis of how many times you heard the tape, of course, other people would disagree with you, right? Because the way some of the things she said in there are things that people clearly disagree with, some of which I have disagreement with. But if I really want you to just kind of answer that last question that I asked, that do you think the remedy of go to the General Legal Counsel versus rather take out that evidence, is that appropriate?
Yeah. So sometimes the question of appropriateness will come later, and we may have our own opinion of I disagree, it should have been this way and stuff like that. For me, human life, knowing who a human being is, it takes time. And these are things that borders on criminality. Now, for me here, there may be, we are told that there are other tapes, there are other evidence that will be adduced later. Who knows other things that will be adduced later on that will confirm certain things and that will give a different meaning apart from whatever. It is in court. The judge said it's going to help her in deciding the case. The weight of it's also up to her. So at the end of the day, we will take it up from there.
Yeah,
for me, my intent is that whether we like what the judge said or not, that is where we go for such stuff. Because you have a opinion, I have mine, and at the end of the day, somebody ought to adjudicate and come to a conclusion. We may agree, we may disagree, we may disagree with it fully, we may disagree with it part and stuff like that. Now, the beauty of it is that we have a chance to go to the next level to find out, and not to stand here conclusively to say that because of this, it is this or this or that. We are entitled to say that, but for me, we are stuck here, and our opinion may not matter unless somebody challenges it and get it quashed. This is what we have, and that concludes the case. That's my humble opinion.
Sure. We have we're gonna go through all one by one. So that's just the first one.
So because you want to look like a celebrity, you have to be away for like 1 hour dressing up. Lifetime legacy. No.
Lifetime. Welcome again. Can we hear you?
Can you hear me now?
Yeah,
we can hear you.
Thank you for the opportunity once again.
Have you listened to it?
I was not expecting to be on a platform today. I live in India and I'm far away, currently in New York. So I least expected that I'll be on a platform today, and I was taking my.
I am in Michigan. I came to Michigan. I have to go back, and I'm still here.
So
loyalty to the show is beyond bounds, So
yeah, I know. So I am glad to be on the platform with all of you, and once again, I think I'm happy to be here.
Okay, so last time, have you listened to our first part, the discussion we just had?
I think if I was following the conversation, it's about the issue going on at the courts at the moment. The applications filed by the accused persons, and also the ruling from the judge. I think if I listen carefully, that is what the subject of discussion at this particular time
you are correct. You are correct. So we are going to go into the second one, and I'm going to take you first, right? And the second part is on the application for an order of mistrial in the instant criminal proceeding. The court went into the legal framework in dealing with and handling. Where are my papers now? Okay, in handling such matters. And then he says that the respondent has rightly cited the case of Twa versus Amwa. So if you have the case in front of you, if you're following, I'm on page 11 now.
Okay.
So the respondents rightly cited the case of Tua versus Amwa. This is in 1980. I believe it's in the Ghana Law Review 815 at page 191, 919. It says in which Justice Corsa set out in general the possible scenarios that might amount to a mistrial and a retrial being ordered. This is very important, so I want us to pay attention to this part. It says, this is Justice Corsa speaking now. Justice Corsa says, in my view, a new trial may be ordered on appeal. Underline the word appeal. In cases in which there has been some irregularity at the trial which amounts to a mistrial. As for example, in this case, so he's citing examples, a defect of jurisdiction in respect of time, place, and person. So if the court lacks jurisdiction, or if there's a defect in jurisdiction in respect of time, the time the case was brought, is it within the statute of limitation? If it's not within the statute of limitation, there's a defect in jurisdiction. In place, usually we don't have that in Ghana a lot because if you bring the case in a wrong court, there's a defect in jurisdiction. Or a person, if the court doesn't have personal jurisdiction over the person of the accused, then there's a defect in jurisdiction. So that is one way to get a mistrial. Second way is let us see if you can put yourself on mute, please.
Okay.
Let us see. Try to put yourself on mute when you're talking now, right? Okay. The second one says, if judgment is so imperfectly worded or so ambiguous or inconsistent that they are too imperfect to amount to a verdict at all. So, if the judgment was kind of ambiguous, it will call for a mistrial. The third one, which is pretty much, I believe, on point, is that misconduct of the jury discovered after trial. Now, here, we are now in a jury trial, so that is kind of sort of mute. I feel like the judge relies so heavily on that aspect, even though we are not in a jury trial. I think the fourth provision here, which says that this misdirection or improper admission of evidence or failure to observe the rules of natural justice, which occasions some substantial wrong or miscarriage of justice, or where for any other reason the trial is a nullity. So the fourth one there, misdirection or improper admission of evidence or failure to observe the rules of natural justice. Okay, that word in there, failure to observe the rule of natural justice, can constitute so many different things. It could mean that there's an application that is pending hearing, which goes to the heart of the matter, but the court did not stay proceeding because the court think, staying proceeding is in the discretion of the court, and the court has to do the balancing to do so. If the court didn't stay the proceeding, that could go into, that could go into failure to observe rules of natural justice. And that could constitute some substantial wrong or miscarriage of justice. So I think that one is much more on point, because what they're asking for, one, is that there is the order of examination of the accused persons that the court has decided, which, the accused person is challenging in court, and the accused person is saying stay proceedings until there's a determination on that matter. But the court is saying, no, we have discretion to proceed. We don't have to stay proceeding. The court is saying there's a misconduct by the Attorney General, which goes to the heart of the main evidence on which the court is based, that prosecution is based in this argument. So stay proceedings until we resolve the misconduct issue before you can proceed. The court is saying no. All this should go into failure to observe natural justice. Do you agree, Lifetime Legacy? I'm asking this so that I can hear what you say before we go into what the judge actually had to say in her ruling. Because the judge, after laying these principles that were laid after stating these principles that were laid in the Tua versus Amwa case by Justice Kosa, it seems to just departed from that by saying that, oh, there's no statutory. Maybe let me go into what the judge says. It just says, in our body of law, as far as the legislation or case law is concerned, there's no provision for the court to declare a mistrial on the basis of an alleged misconduct of a lawyer, either for the prosecution or the defense. And I disagree, because if the conduct of a lawyer would constitute a failure to observe, natural justice, right? The rule of natural justice, then it's implicated. You can't just say that there's no law, because there's no law specifically saying if a prosecution misbehaved in Ghana, you couldn't stop a proceeding and deal with that. You are not going to deal with that, especially if it touches on the main evidence. So I kind of disagree with that. And then it says, having laid the foundation that basically whatever power the court is being called upon to exercise in this case, being a criminal crime, must clearly be backed by statute, as stated by Zukrada. The absence of a specific statute to the effect no mistrial can be declared or ordered. Some reference may be made to some foreign cases. However, the case law of this jurisdiction, these foreign jurisdictions, are based on their legislation, and as such, we may have to locate analogous legislations to make those cases applicable within our jurisdiction. The instances stated in the Tua case are not applicable in this instance, which I disagree with. What do you think?
Thank you, Alfred, once again for the opportunity, and I'll also say hello to our viewers and listeners. Before I come to answer the main question you posed, permit me to use a minute to build a few things, then I come to the answer to the question. Okay. So I think I will start by saying that any person who is or has been prosecuted by Godfred Dami at the right time or the appropriate time should appeal for whatever ruling was given. If the person is not happy, the person should reapply and appeal for proper determination of the case. Why am I saying this? I'm saying this because it is from listening to the conversation between Godfred Dami, the Attorney General, who is in the office for attorney, and also making sure or have the responsibility of making sure Ghanaians have a fair justice. The evidence and what we have heard so far points to the fact that he is not doing what is expected of him. He is rather procuring judgment. And on that matter, every person who is a victim of him, or any person he have taken to the court so far, the person should and the judgment have been given and the person is not happy. The person should go back for an appeal or file back to the court to disagree or whatever the outcome of the ruling is. Because all the judgment, there is evidence out that all that he has been doing all this while is procurement of judgment. Now, coming back to your main question you asked, it looks like the judge in my
before you go on, have you given that that advice to Sedinam Tamaklo?
So we lost him quickly.
Oh boy.
Yeah. So Afa, maybe we can bring you in and then we wait for him, right? So Afa, the issue I'm having here is this: that there is a reason why we have precedents, right? They set the law that must be followed. The respondent in filing this application for mistrial quoted a specific case, Tua versus Amwa, and we went over Tua versus Amwa, and I think I am pointing to the fourth criteria laid in that ruling with regards to when can a mistrial or a retrial be ordered.
Misdirection or improper admission of evidence.
Correct.
Or failure to observe the rules of natural justice.
The failure to observe the rule of natural justice is the one I'm kind of honing on, right? Here's why. My reasoning is that although there's no specific law, oh my God, we've lost far as well. Well, for those listening, my reasoning is that although there's no specific law saying that a lawyer's misconduct cannot be subject of an interlocutory proceedings or a mini trial, which upon there should be a stay until that mini trial is resolved. So all I was saying is that although there's no specific legislation pointing to the fact that a lawyer's misconduct can cause for a mini trial to be held, and while that mini trial is going on, that the main trial be stayed, there is case law pointing to a failure for observation of natural justice. And when you hear words like that, what a failure for observation of natural justice, the question you need to ask is, what constitutes natural justice? Can the conduct of the prosecutor cause there to be a failure to observe natural justice? Especially if the prosecutor is tampering with evidence against the human rights of the accused. So I think that the principle laid by Justice Kosa here gave us guidelines, and that principle should have been followed by the court. But the court didn't follow that. This is what the court says. The court instead says that in our body of law so far, as the legislation or case law is concerned, there is no provision for the court to declare a mistrial on the basis of alleged misconduct of a lawyer, and I disagree. There is, which was quoted, Tua versus Amor, which was right in front of the judge, which the judge herself quoted. But why she refused to use that, it bothers me. This is why, sometimes people question our judicial system, right? Even if she wasn't going to use it, right, she's supposed to favor us with some analysis. She hasn't done any analysis. So she says, her only statement is there's no law, legislation or case law. But you've been given the case law, which you quoted. And then she went on to say, having laid the foundation for the basically whatever this power is being called upon me to exercise, in this case, being a criminal trial must clearly be backed by statute as stated by this. So in other words, she needed a statute to tell her to do that. And there's no such statute. And say the absence of a specific statute to that effect, no mistrial can be declared or ordered. And I think that is wrong, because the procedure, how you do that, has been laid out in case law by the case of Tua versus Amwa, which she quoted, the fourth or the D, the item quoted, and in D specifically supports a failure of observation of natural justice as a means of ordering a mistrial. Do you agree or disagree?
I disagree. I disagree with your disagreement. Now, here is the case. So let's go specifically to what that said. And you see, it is not always the case that even when somebody makes an allegation and quotes a precedent, and it is not always the case that you must follow that precedent. But you must.
She was making a reference to the fact that there is no law in Ghana for legislation and case law. Case law is precedent. The cases.
Case law.
So you cannot say there is no case law at the same time that you actually quoted a case law on point, which was provided to you by the respondent. The respondent gave you 12 versus Amwa. You lay out the principles on page 11 here of what 12 versus Amwa says. Then you went on page 12 to say there is no case law. That doesn't. Or it doesn't apply here. It's not true.
Yeah, but for me, right? Even
it doesn't apply, right? You have to do the analysis for us and tell us why it doesn't apply. The judge just telling us it doesn't apply doesn't give us any room to not criticize the judge. You know what I mean?
Oh, criticism is what we are doing right here, and we're going to do that now. Quick one before he comes in. Now, when let's even rely on the D, misdirection. Okay. So we can say that the Attorney General
we are not focusing on the misdirection because this is a disjointive. It's a disjointive rule, right? It says misdirection or improper. So if it is not misdirection, it's something else. So misdirection is one part. We don't care about misdirection because
it's not about misdirection. We don't care. We only care about evidence of observation.
So starting from all. Failure to observe the rules of natural justice.
Okay, so at this point, right? what is the act that points to failure to observe the rules of natural justice in this state?
The way case law works is that it's add to the act. Common law develops from the judge's rulings over time.
I understand that. Okay. But if you are quoting, if you are standing on this,
hear me out. You don't need a specific act to say what the case. That's why the case law
not act, not legislation.
Right.
Action. What was the action? What is the action that fits into this? What is the action?
Yeah, the action standpoint is that the evidence being used by the what do you call it? The prosecutor, right? Seem to be an evidence that the prosecutor is willing to have witnesses lie about.
Okay, so
we got that on the tape.
So the AG has submitted. Which one was a lie? Which of what they has submitted was a lie?
Well,
which of the evidence the AG or the prosecution has provided to the court was a lie?
Yeah, the fact that
because he has closed his case. You see, that is also very important.
Yes, why? The fact that the AG proffered evidence to show that there was no authority, right? There's no authority in possession of the deputy finance minister at the time he authorized the letter of credit. That is not a correct assertion for him to make. And of course, the judge is gonna make her ruling based on that.
Yeah, that will come in. The point is that
now we see that the Attorney General, realizing the weakness of that evidence, is tampering with witnesses, right? To testify in favor of his view on the evidence. And that action itself, right, is called witness tampering. Right,
Alfred. In one of the
hold on.
And so we are saying that
statement,
that action
tampering, that witness tampering
was likely to result in
was based on the audio, right?
But hear me out. The affidavits provided by Jakpa, right, goes beyond what is on the audio. It goes beyond the visitations and all these other things that the Attorney General may not be the one uttering it, but he did not reject them even on the audio, which any lawyer, that constitutes agreement implicit. You are agreeing by
that did not come in. Okay. So the visits and the meetings and all that kind of stuff. Where? With who? And all that kind of stuff.
With Jakpa. And the thing is that if it can be established that he's been doing that, right, then all the evidence he actually brought in the case should be subject to same inquiries, how he procured them. So I'm saying that because they are all fruit of the same poisonous tree, right?
Yes.
He seemed to be tampering with witnesses in order to support his case.
Let's not overstretch ourselves.
Failure of.
Let us not overstretch ourselves.
No, you asked me the question, so I'm answering it.
Yeah, we quick one. Else we're going to go into areas that are not in. You see, in the court, right? You make an accusation, then you provide evidence to fit it. Okay. Now the evidence we have right now is the tape. I am not aware of anything providing pictures and videos and places they met. If you read that anywhere,
go ahead.
If you read that anywhere, we can discuss that. Now, all that we are talking about is that he called you, he has been calling you otherwise. On there, you say you'll be meeting and all that. Okay, so which of the meetings was inappropriate, was illegal? You mentioned the name of Johnny Kolendi and all that. Bring all of that in there.
No,
Alfred.
Last week I covered.
Let me hold
on. No,
let me say this and then you can come in.
Try this out.
Last week I kind of pointed to you that even the tape will come in through a witness, right?
Okay.
So you realize that when they filed the application, the tape was the drive was attached to the application, apparently I learned. But after that, when they came to the hearing on the 6th, right, as they call Jakpa, so that the application was being raised, they're moving the application. And as you're moving the application, that is when questions get asked to the matters you lay out in the application. And then you profit evidence that way. But here is the case where they are applying for an inquiry into the conduct of the Attorney General, which would have been the basis for which all evidence relating to such a misconduct will be proffered. You just don't proffer all those, and once they proffer all those the evidence related to such a misconduct, a determination would be made as to whether the evidence proffered goes to the heart of the matter at hand, to the extent that it will constitute a failure to not observe, a failure to observe natural justice.
And last week I told you that if you do that as an attorney, as a lawyer and stuff like that, you see, you can choose to do that, but you are not always going to have your case. When you file a case, and you put in your evidence. Now, when they went to court, the judge told them that they were not going to go through oral submissions, and that she has enough of whatever they submitted.
Yes, she has enough
going to make the case.
Mm-hmm.
So if you have something and you put it there, thinking that during oral you're going to tender it, I don't know where you're getting that from. Now, in the course of the trial, if you have new one, you can put it in. Don't wait. Why don't you put everything in there? You are talking about the misconduct. Hold on. You are talking about the misconduct of the Attorney General. You have evidence of them meeting in places. You have evidence of phone calls. You have evidence of other things and stuff like that. But meanwhile, you've listed about 5, but you gave us 1. You are going to bring the other one later to still talk on. The court doesn't have time to back and forth.
But what you are asking for is an inquiry. What is the point of the inquiry if you have all the things you want already?
You that the inquiry is, the court is not the place for the inquiry.
Which I think constitutes.
Go to Yoko, go to all these places and then procure your evidence.
And that's where it points to failure to observe, natural justice. Yeah, okay. Rules of natural justice. Okay, so let's bring my boy in again. Welcome back.
But before that, I was asking him the advice he was giving about people that have tried. Have you given that advice to Sednam Temaklo?
Yeah, as I was saying earlier on, I'm saying that it is now established beyond a reasonable doubt that Godfred Dami, all the prosecutions and the judgment he have secured, he procured them. Jakpa, Jakpa is on record to have stated that beginning of this case, the Attorney General called him and requested from some documents from him. And on the condition that if he make those documentations available to him, the Attorney General, and cooperate with him, he will let go of Richard. And Richard also complied with him at a point by giving out some of those documents to him. The question I'll ask, which you mentioned earlier on in your submission, that the second accused have been discharged from the case. Could that be, I'm only asking a fair question, that he complied with the Attorney General to his satisfaction, could be the reason why he had been acquitted out of this case? That is an area we also need to explore. Now, going on, Richard has also made it clear, or I have gotten the wind, that there are many evidence relating to his communications with the Attorney General, which sequentially will also be coming out to prove his case that he's doing everything to procure judgment as far as the I know I'm not a lawyer, but I know when trial judges are sitting on cases, they are not supposed to be listening to the commentary outside. What is going on, what the opinion of the citizenry are. But this very judge is listening to radio and watching televisions alongside sitting on the cases. So I think some of the comments coming from the judge it's a fair indication that she's not being fair to the accusers of in these particular cases, and for the judge to come to a conclusion that he have not gotten any evidence to that effect as far as she have listened to the case or the tape many times, for me, give a fair indication that the judge have compromised herself to say, if I will not be far to say that. I am saying that because
we can't go that far, though. I don't think the judge has come.
Okay, let me say that it is too early for her to conclude in that manner. Can I put it in that manner?
Okay, sure.
Okay, so it's too early for her conclusion. I'm saying this because you should have given the people the opportunity to explain. Evidence sometimes cannot be just what do you call it? What you want. Demeanor of the accuser and the respondent of the demeanor of the what do you call it? The prosecutor and the demeanor of the accuser could also go a long way to give an evidence of how things are going. So I think the judge is unfair to have come into that conclusion that she will not what do you call it, directing them to go to a different quarters if they have to get a judgment on that distance. She should have, natural law of justice demands that you give the people who are accused the opportunity to explain themselves. So on that note, I strongly disagree with the judge ruling, and I will suggest the accusers in this case should appeal probably to the appeal court. They might probably be getting a fair hearing when that happened. But from what I just, like I said earlier on, it is unfair on the judge to come to that determination or come to that conclusion.
Okay, perfect. So, before you come in, right, let me lay down some quick background. And I think on this matter, we should close this matter by reciting the counts or the statement of offense one more time so that we can reorient ourselves before we go into the issue of the application for stay of proceeding in the instant case, right? So the first count here was, or count one, statement of offense was willfully causing financial loss to the Republic contrary to section 179A3 of the Criminal Offence Act. So again, when they say willfully causing financial loss, willful is
deliberate, in other words.
Deliberate, knowing what the correct thing is, or knowing that you are causing a financial loss to the state, but you did it anyway, deliberate. So you have to prove that deliberacy. And the particulars is that Ato Forson between August 2014 and April 2016 in Accra, in the Republic of Ghana, willfully caused financial loss of 2.37. So if you're following, I'm reading page 13. Okay, 2.37, 2,370,000 pounds to the Republic by authorizing irrevocable letter of credit valued at 3.9500 to be established, out of which payment amounting to 2.3 were made to Big C General Trading Limited of Dubai for the supply of vehicles purporting to be ambulances without due course and authorization. So, I want us to pay attention to this, right? The letter of credit is actually supposed to be for 3.9. The payment that was made was 2.3, almost about 1.5 difference. And so the argument was being made that there is the vehicle portion and there is the equipment for the vehicle portion, and the two would have come to the 3.9 that was supposed to be the coverage of the letter of credit. Only the 2.3 portion was paid, which is just for the vehicle. Okay, so you have to know for sure that A vehicle for which you just pay 2.3 does not constitute an ambulance unless you put the equipment in it, and you have to pay 1.5 additionally in order to get those equipment into the vehicle and call it an ambulance.
Okay.
Just so we can kind of follow the same set of facts. So that was the first offense, and when you break that offense down, the letter of credit was supposed to be for 3.9, 2.3 was what was paid, and it was the 2.3 for which this case is being brought. Count 3. Count 2 and count 4.
And why the division? Why the division?
Because there was, if you look at the contract, there was supposed to be vehicles plus equipment into the vehicle. And so you pay for the vehicle separately and pay for the equipment to be installed in the vehicle as a separate, and the two together forms an ambulance. If you just take the vehicles by their own and say it's an ambulance and therefore it's looking at it, there's no equipment in it and it's not useful, it may constitute misunderstanding of what the contract says. Does that make sense?
It makes sense.
It makes
Today
sense.
I should be paid for representing
Why?
NDC, you know?
No,
I'm just saying, go ahead.
Alfred, when you are done, there is something I would like to add.
Okay, let me just go through
add before he, because you may not get the time. We got it.
So, Alfred, are you aware that the fittings that will make the ambulance complete ambulance have been in the harbor since 2016? Are you aware of this?
That allegation has been made. I don't know for sure.
Who pays for that? Who authorized the letter of credit to pay for the equipment?
Well, so basically, as part of the letter of credit, if you observe, the letter of credit is supposed to pay for 50 ambulances in one sloop or in one chunk.
So the equipment that are supposed to be
hold on. One after the other.
So the 2.3, I believe, paid for the vehicle. The equipment was supposed to be what the 1.5 paid for, right?
And had credit facility been issued for that one?
No.
The letter of credit is supposed to be for the entire 3.9.
Yeah, I understand that. They are talking about the equipment came and was stolen or has been in the harbor forwarded. So who authorized the equipment if credit was not issued for that?
Okay, so if I listen, right? When you establish the letter of credit, right, and the whole NPP is getting confused with what letter of credit actually does.
Okay.
When you establish a letter of credit, right, it's a guarantee to the supplier that the supplier will be paid, right?
Okay.
And this was happening between 2014 and December 2016.
And we understand all of that.
So take the dates into consideration as we kind of talk about this, because remember, after December 2016, government changed hands. So the letter of credit was delivered for 3.9.
Okay.
Now, when the bill of lading came for the vehicle, that bill of lading gets submitted to the bank to disburse on the letter of credit based on what has been shipped.
Okay.
So if the equipment wasn't shipped at the time, there couldn't be payment for it. So upon the time that the equipment was shipped, government had changed hands and you guys didn't pay for it. That is the argument.
No, that's wrong.
That's the argument, because
that's wrong.
Went all the way to 2016.
You mean from 2014 to 2016, 2 years?
No.
To ship equipment?
No. I'm not saying that the cars came in 2014. This whole contract in terms of starting the letter of credit and all the negotiations.
When did the first ambulance come? When did the first ambulance come in?
2016.
No, not 2016, 2014.
Well, okay, whatever the case is, we can find that.
The ambulance was in 2014.
Well, we can find that.
After 2014, I am not too sure if
I am what date?
Ato Forson was the deputy finance minister.
Not 2016, 2014.
Okay,
I am saying that yes.
Started in August 2014, right?
Okay.
That was when I believe the negotiations started. So August 2014.
Okay.
That is a couple of months before we got into 2015, right? So I don't know specifically what date the ambulance was delivered, but this is something we can find out. But I'm saying that it stretched all the way between the period where he was the Deputy Minister of Finance, which ended in December. So that's what the court actually considered. Matter of fact, April 2016 is what the court considered as the time frame between which when this happened, right? And so the first portion was delivered and 2.3 million was paid for that. All right, even though the letter of credit for the 50 was supposed to be 3.9. So it begs the question, what is the rest supposed to pay for? And the argument that the NDC is making is it's supposed to pay for the equipment, the equipage that is necessary to complete the ambulance. But that wasn't paid for. Why? Because government has changed hands. Okay, so let me go to the third count. The second and the fourth count were dropped because they had to do with Dr. Animema. Okay, because his case was dropped. So third count says
because he was able to cooperate with the Attorney General to procure what he's looking for.
Well, we'll see about that, right? So count 3 says, which is also on page 13, starting from page 13, says willfully causing financial loss to the Republic contrary to I believe it's the same thing, 179A3A of Criminal Act of 1960, Act 29. And he went on to say that the particulars being Richard Jakpa between August 2014 and 2016 in Accra, Republic of Ghana, willfully caused financial loss of 2.37 to the Republic by intentionally causing vehicles purported to be ambulances to be supplied to the Republic by Big C General Trading Limited of Dubai without due course. And then fifth says intentionally misapplying public property contrary to section 1(2) of the Public Property Protection Act. And in this case, say Ato Forson state the same date range again, says that he misapplied the sum of 2.37 being property by being public property by causing irrevocable letter of credit to be established against the budget of the Ministry of Health in favor of Big C Trading Limited, Dubai, for the supply of vehicle purporting to be ambulances without due course. So, if you think about this, right?
Before let me help you. Let me help you. A question you asked.
Yeah, let me ask this thing to a file. Then you can come in.
That will help. A question you asked earlier on. When did the equipment arrive? So this is on what do you call it? City News. It says that the equipment or the container was loaded and shipped and received or came into the country by 2016.
What day?
No, by 2016 it's not. By 2016 it's not. It's not a no. You can't take that.
So you can take that and everything, and arrive in the country on 2016. You can check this on.
No, no.
Okay,
you see, now you say by. You are
online.
You are reading. You say by. Now you say on.
Okay, let's
2016. No, I'm saying that all those things and the shipping and everything arrived in 2016. The word over there is in 2016.
Is it the equipment or the vehicles? We want to understand the
container of the vehicles and the installation. That he used the word over here, install equipment to be installed. Equipment, the medical equipment to be installed in the ambulance. Can you say what you are reading
on the platform so we all can?
Can I read the platform?
If I let him finish,
he said that container loaded with medical equipment to be installed in the ambulance was shipped and arrived in 2016. You can check this on City Online.
Okay, we got it. So 2016 is when the containers came. I mean, the time frame of the transaction was between 14 and 16 anyway, so we got that. Okay, so I'm saying that, right, this last count here, which is count 5, which discussed the Public Property Protection Act, it says that, of course, Ato caused to be established a letter of credit against the budget of Minister of Health. So let me ask you, budget. How is budget set? The budget would have come from the Minister of Health, right, with regards to procurement of ambulances, and all that would have been detailed, right? and funds would have been allocated in the budget for that purpose, for the purpose for which the Deputy Minister of Finance authorized a letter of credit to be made against. So it's not like the Deputy Minister just smoke out some ambulances that need to be purchased that were not programmed in the budget. This is programmed in the budget.
Oh yeah. So listen.
Let's step by step. This is programmed in the budget, and he just caused a letter of credit to be, which is not even paying, to say that, oh, you the contractor bringing this in, we guarantee that when you bring it, we'll pay you. That was all this guy did, right? And so the question was whether he had authority to do that, and of course he called the finance minister to come and testify in that regard.
And he couldn't provide any evidence that he authorized.
The finance minister testified and said that he authorized his deputy to do it.
Okay, but we don't do that.
The seal of the letter.
Doesn't necessarily come from the finance minister.
Hold on. You just go there and say, hey, issue things like that costing millions of euros. You just go and say, hey, I authorize you to just do it.
But the thing is, I'm saying that, right? The Deputy Minister of Finance work on, it's a deputy, right? The Deputy Minister of Finance.
Yeah, a deputy minister is not a minister.
He's not a driver's mate. He's not a driver's mate.
Hold on.
Deputy minister is not a minister.
But I'm saying he works with the authority of the minister, right?
Okay, but authority doesn't come orally.
But also,
they were just playing the court. It's not true.
What does the authorizing officer do? Hold on, guys. Hold on. What does the authorizing officer do? The authorizing officer approves, right?
Okay, but you don't just use your mouth to say I approve or I authorize you. You have to do that in writing to cover your
So the approval was already taken to the parliament, and parliament approved the budgets.
It doesn't work like that.
So what doesn't work like that?
Abuse powers. What do you
mean?
The
parliament actually already authorized the procurement of these ambulances.
A deputy minister is not a minister. You cannot get
this. My God. Go and see the all the approvals. I mean, we can take that and interrogate it separately because we don't want it to kind of distract.
Let the MPP
why? Okay, now listen. Why
the MPP is trying to set a new standard for us?
And that it should have come from above because they are layers, and these are basic. You think a director, a deputy director is a director? No, assistant director is a director. No. Let us not confuse ourselves. Let's go on. I'm listening.
So now that we have that foundation in mind, so the foundation we have in mind is the type of charges that we are talking about, right? What actually goes to the heart of this litigation are those ones that we've just laid out. Now let's look at the last piece and then we can get out of here quickly. The last piece is going to deal with on the application of stay of proceedings in the instance proceedings pending the determination of applicant's motion for mistrial and the application for stay of proceedings pending appeal. So it says the first application for stay of proceedings pending appeal filed on the 21st May of that mainly premised on A1's conviction that the court made an error of law in decision that A1 first cross-examined A3 before the prosecution crossed A3, and the order is in a breach of the constitutional right to fair trial. The second application filed on 28th May 2024 seeks to stay proceedings pending the determination of the applicant's motion for mistrial. In this ruling, the motion for mistrial has been determined, and as such, the second application for stay of proceeding pending the determination of the process has become moot. Okay, so we agree. Because they decided that there's not going to be a mistrial, of course, any application to stay the proceedings for the mistrial is moot. Even though I think the mistrial determination is wrong, I agree that they have to throw that one in. But in general, he came back to say the law on stay of proceeding in criminal matters is set out below. So, it says, it is without question that the matter of whether or not a court will stay its own proceeding is discretionary, right? But when the court is doing that, the court has the power for the decision in the relative, and then he kind of quoted Supreme Court cases, even the recent one on the coup d'etat people, right? The people who they accuse.
So quick one before we go on to establish this letter of credit. So So the letter of on August 7th, 2014, Dr. Ato Forson, as Deputy Finance Minister, wrote to the Bank of Ghana for the letters of credit covering the ambulances. Okay? So it was issued in 2014. So you're telling me that the letter of credit was issued in 2014, but the ambulance got into Ghana 2016?
No, the letter of credit doesn't mean somebody's paid. Oh, let's be clear on that.
Yes.
When you're signing the letter of credit, it doesn't mean somebody's paid. It just means that per contract, you are saying that I'm establishing a guarantee to pay this person upon conditions. And those conditions have to be satisfied for payment to be made. One of which includes citing of the ambulances themselves. So if the ambulance were not cited until 2016, a letter of credit that is created in 2014 has no, there's no wrong.
When was this cash?
You could have created a letter of credit.
Do we know when the money was cashed? The 2.3 was cashed. Do we know when?
Well, you can find that out too, right? Because those will be the things.
2.3 were cashed after the first 50 ambulance arrived in the country.
Yeah. Well, bill of lading.
When?
In 2016.
Well, we can look into that, right? So those are facts in front of the courts. The case, the ruling hasn't really gone into that. But I believe if you look at the ruling on no case application, which was released on March 30th, because remember when the prosecution laid its case, the defense filed submission of no case so that the case can be dismissed. In other words, the prosecution didn't make a case enough warranting defense. And then the court came back and said, there's prima facie, so established it. So go ahead and open your defense. That ruling contained all those details. So if you like, we can take that for next week or take that for another day. Me, I'm enjoying this stuff. So let's go. So if I'm on the matter of when you can actually stay proceedings, the court went on and stated, precedence over precedent. For instance, it says the case due to pending the determination of constitutional questions. So it laid out, principles that were established, and I'm going to go through those principles. One is that application for stay of proceeding is one which invokes the discretionary jurisdiction of the court based on the peculiar fact placed before the court. Therefore, that jurisdiction cannot be exercised from a vacuum. Since it is discretionary, it must be judicious and ought to take into consideration judicial balancing of any alleged imminent injury or prejudice to the respective rights and interests of the parties pending determination of interlocutory appeal. So if there's an interlocutory appeal, there could be, of course, an application to stay, but the court would have to use judicial balancing to see that everybody is treated fairly in making that determination. Two, he says, in criminal proceeding, as is in this instance, the exercise would involve the balancing of the public interest which the respondent represents in the expeditious prosecution of alleged criminal conduct as against the interest of an accused who is presumed innocent until otherwise pronounced by a court of competent jurisdiction. In so doing, the court ought to be mindful of the rights of accused whose trial ought not to appear unduly rushed, right? While there is a pending intervening judicial process in order to avoid a potential risk of compromising the outcome of the process and the rights of the persons standing trial. So the court is saying that in criminal matters, especially for you to consider whether to grant a stay or not, you take into consideration the accused person's right so that you don't rush the trial. The trial should not appear as being rushed, because if you do that, it impacts on the rights of the accused person. And there's a third one. She went on and on and on. It says that is why the consensus of judicial authority requires an application seeking a stay of proceeding pending the determination of an interlocutory appeal to establish a case of special kind, often referred to as exceptional, in order to succeed. All right. And then she said, therefore, where the situation is embellished in such terms to appear as though there is a restriction on legal avenues albeit within acceptable judicial practice, that situation cannot be said to be exceptional. In my view, a situation would be exceptional if it be specifically tied up to an eminent development in the judicial proceedings, which, if not stayed, would irreparably prejudice the case of the applicant. It must be one for which the right of the applicant to a fair trial will suffer limitation or restriction which is unwarranted by law. In other words, an applicant has a duty to demonstrate that if a stay is not granted, it would overwhelmingly suffocate the tenets of justice while the interlocutory appeal is pending. So, the thing is, there has been a couple of interlocutory appeals. One is, to the order of cross-examination that they were challenging, and the mistrial that they were challenging. And so the question is whether those things are exceptional, whether they will suffocate the tenets of justice if the interlocutory, if a stay was not granted until the interlocutory appeal is resolved. And so let me ask, do you think that the matters brought up are such that they are exceptional so that they should be resolved before we continue the case, or we should stay the case and resolve them? And now resolving them, do you think that if we don't resolve those things, this case would have, although it's progressed, it's been ongoing for the last 2 years, it would have seemed to be rushed? Because what is the point of not resolving those issues before proceeding? Why are we in a rush to say, oh, even though you brought this application, we don't care, we're just going to proceed anyway, especially if those are going to impact the right of the accused person?
Are you talking about the one that they filed at the Supreme Court?
Yeah, the Supreme Court's one.
And what was the ruling? He told that you're sorry. That as far as I'm concerned, if I'm going to be contempt of the Supreme Court, I'm not aware of any such suit. Right?
What do you mean?
The judge said he's not aware of anything like that. He has not been served.
Well, but the thing is, if you cannot
go to a court and say I've sued you, so stay proceed.
This is where people were quoting the practice guidelines, right? The practice guidelines states that when you file those applications, even in injunctions that we know that the president, for instance, when the LBGT thing was going on, he exercised the power of a state just because he's been served. Even the court have done that in the past, where just because an injunction is filed, that they stay proceedings so that even though the court was not served with those injunctions. But the point is that again, staying of prosecution, if you ask a specific court to stay a proceeding, it's in the discretion, and the judge has to kind of evaluate that. So I know the judge is in here, bosom, to evaluate this, but is it fair for her to refuse this, right? When, those applications have been filed, because it's clear the applications have been filed. She may not have been served, but she's aware that they've been filed. The service only plays one function, right? To notify you of an application that has been filed against you. If you already know through whatever means, because the judge cannot say she doesn't know that they were filed. She's only saying she was not served officially, but she knows that they were filed.
Okay, so all that you're saying are in, and the question of what it means to the overall trial is a different thing. You see, if I know that there's a car here and that car is visiting me, not having come to my house to visit me cannot be assumed that I've seen the car, so the person is in my house. Okay? There is a process, there is a procedure. And these things are law. You don't sit somewhere and say, I've read it here, I've seen it here, and stuff like that. If it has not come to you, it hasn't come to you. So that is one.
Well, see, the judge, I love this thing because, the judge has to give us a reason for why she even reached the rulings. And if you look at even this, it says that in criminal proceedings, there may include a challenge to the trial court's jurisdiction or propriety of charges, which, if upheld on appeal, will potentially vitiate the entire proceeding or bring the continuation of the proceeding in the trial court to end. In any such situation, an exceptional circumstance may be said to have arisen, and therefore it may be judicially prudent that the trial proceedings be stayed pending the outcome of the interlocutory appeal. It is, however, significant to note that the mere expectation that the interlocutory appeal will succeed is not a sufficient ground to grant an order for any of the proceeding. This is her conclusion. So she said, in this case, there's quite clearly a challenge to the jurisdiction of the court and the proprietariness of the charges before the court. There is also on the record fact that the arguments before the Supreme Court have been virtually concluded, it is likely that the matter would be disposed of quite expeditiously. So, in other words, it says, without going into more detail, it is obvious that none of the instances set out in the sessions by His Lordship Tanko, which is all the things I've been reading so far, will be applicable here in the circumstances of this case. I have noted that generic notice of appeal, which is the foundation for the application to stay proceeding pending appeal, I have noted that even the alleged error of law was not particularized. It seems that there is no real intention or impetus to prosecute any appeal in the foreseeable future. I hold that there are no exceptional circumstances to merit the grant of stay of proceedings pending appeal at this stage of the trial. So, in doing so, she's faulting the NDC lawyers, and me, I think the NDC lawyers too. Again, you guys, they need to tighten their belt, especially, or they need to tighten up. They use a generic notice of appeal, which the judge thinks.
And you see, well, they can go any route.
They are not particularizing, for instance, the errors the judge is accusing of not particularizing
those. About this case. We have an idea how this, but it is up to them and what they do. You see, when I keep on saying that you may have a good case.
The judge, right, when she's making those things, when you say they only use the notice of appeal, okay, if that is a form, I would have wished she can elaborate in that notice of appeal what makes it insufficient, right? The judge need to tell us that. She didn't say. She said, I've noted that even the alleged error of law was not particularized. Tell us what they gave you that has not been particularized, so that we can also, her analysis, she quote a whole lot of law, but scanty analysis. Her analysis is because I quoted this law, this is my conclusion, without giving us the breakdown, giving us analysis.
But she also said that if she was to go on more details, I mean, even with this one, we have 40 pages.
She's a judge. That's what she's supposed to do.
We have 40 pages, so this is enough.
The 40 pages of 20 pages of law that she quotes that she did not analyze.
Okay, so if you read one of the authorities you cited, the one you said the point 4, right? One of them talk about
the 12 in the 12 verses.
Yes, the 12 verses. It talks about when a judgment is delivered, right, and it is couched in such a way that it is either ambiguous or it is whatever. You can appeal it too.
But those factors laid out in that judgment by Justice Coder as factors to be used in deciding whether to grant a mistrial or retrial are disjointive. They are not conjunctive. It's not like you have to have all those factors in place.
I understand. That's why I'm quoting just one.
The factor you are using right now. The factor you're using right now is now on point. The one on point was the D that we kind of cited, right?
No, the D is for. No, I'm talking about you right now. You are talking about the judgment she gave, right? Mm-hmm. And that she just gave cases and did not analyze it enough for us to get the whole import of what she's saying. Is that not what your conclusion you want to
Right.
Uh-huh. Right. So they're all part of. When you read the whole thing, and objectively, it is pointing to a certain direction. You can make some conclusions that, okay, even though the thing is this way, the thing is written in such a way that is pointing to this direction.
Oh, you mean in a future mistrial application, this could be a ground for mistrial, right?
Exactly.
And yes, so this is my argument has always been that even if you want to file for a mistrial, you want to file for it first and have it denied so you could preserve the point. Because if you're going to an appeal, you have to preserve the point that I raised this in trial, and the trial judge didn't pay me no attention, so I'm bringing an appeal on it. If you have not raised it, then you can bring an appeal over it. You can appeal something that was not addressed. You know what I mean?
Yeah.
So it is good that they actually brought it here now so that the judge has passed her ruling and it preserved the point for subsequent appeal. So you're right. And in that case, we can use some of the factors laid out by Justice Coder.
Yeah, so in effect, Amozu, you see, this whole idea. I'm enjoying all that is happening. I don't care how long it takes. Whatever the defense think is relevant in this case, because we are not dealing with no mean lawyers. So There is only one person I don't like in this on the NDC side, but the others are doing fantastic. Okay, and anything they should be.
I would
But
have
we also
been
know
surprised
why.
if you say you like him.
You see, I am also not surprised because you see, as a lawyer, right? If you know where a particular case is pointing, you want to do as much drama and play on the case for it to travel as long as it takes, and more so when there is an election and we don't know what the outcome will be, so that if it goes our way, not impossible, right?
So
then we kill it.
We can
We
find
don't
only
pay attention to it.
Ifa is telling us that they want to get to the conclusion of this matter before they leave to power.
Oh no! You can't do that.
Yeah, that's what you're telling us.
Anyway. No.
You guys want to see the conclusion of this power?
No.
Case
You don't.
before you leave power.
You see, you can't take your case to court and expect when a judgment
If
comes.
that is not the case, right?
You
Then
can't.
why challenging all this application for stay for certain proceedings to take place, for certain interlocutory, for certain temporary trials to be held to determine certain matters before going into the substantive, because those matters impact the substantive. If you're not in a rush to do this before the election is over, why are they then?
It is not a rush. When you bring something, it must be of
this is a
substance.
criminal trial and somebody's human rights are at stake, right? Because we are about to deprive them of their liberty, put them in jail, sort of, So it's important that we check all the boxes.
No, the case they took, to the Supreme Court, you see, when you read it, you see, and when you go to these judges, when you go to this court, don't think that whatever you take in there, you are going to have, you are right. You are at the mercy of the judge based on the law. So they also know, and they read the law and they give their judgments. So make sure you don't go and do theatrics. Go there with proper this thing. In fact, truth be told, the NDC plays too much into the gallery other than going into the law. And when you do that, they'll just throw your case away. And then you come there, hey, they're deceiving me, we're rushing, we're doing this. No, nobody's rushing. A police case has been there for how long? Huh? No one is rushing anything. Sadinam has run away. And
all those cases need to be re-adjudicated.
Okay, we've been here for some time, right? Go ahead, finish up so we can.
Know that the Attorney General and the NPP are trying to prove a political point and are going around buying.
When you were taking a foreign minister. When you are taking a foreign minister and a former friend, we are taking foreign ministers. You are taking lawyers. You were taking them to court. Why were you doing that for political reasons?
Yeah,
okay.
Saying that.
All right, guys.
You guys have a fair judgment at your time. Yes.
Okay, guys. Let's
judgment.
And that's okay, guys. Let's try to wrap this up, right?
So
go to the court and do theater. You've been doing.
I can assure my brother Ifa, and he should mark it where rainfall will not be able to touch.
Okay.
Now that we know, and Ghanaians know for a fact, that all the so-called judgment and the prosecutions and judgment they have secured, now that we are fully, it is fully established that they were judgments that were procured, I can assure my brother Ifa that when the next NDC government comes to power, which we are coming, whether they like it or not, all attempts to rig the election, I can assure them it will not materialize. If they come, every
Rollins told us to expand.
We will match you people boot for boot. If you draw a sword, we will draw a sword. If you draw a gun, we will draw a gun.
Okay.
No man is a man than anybody in their country, Ghana. We are all equal stakeholders in the country.
Okay.
So I am telling my brother Ifa, you should mark my words that whatever they are doing to imprison people unlawfully, procuring judgments, to get buying judges to give false judgment and all those things, at the right time, Ghanaians will have a fair and lawful trial. So, like I said in my earlier submission, every single individual who during the era of Godfred did not get a judgment on his favor should know that those judgments they got were procured, and those people should go back to the court, and at the right time they'll get judgment.
Okay, perfect. Guys, let's not fight. Let's not call for guns and all that stuff, though. We want peaceful Ghana. The NDC and the MPP should not even think of it. They are custodians of power on behalf of all of us, and we are not gonna, let them destroy this country. In those utterances. So, Efo, relax more. We are not using guns.
No,
okay.
I'm not. No, it looks like they are trying to portray to us that they are more Ghanaians, or they own the country, and every other people in the country are subject to them. And it is time we prove them to know that he who called for equity should come with a clean hand. I'm not saying that we are going to draw a sword, but they should not try that they will draw a sword. If they draw a sword, we also draw a sword. That is all that I want to say.
Boot for boot. That's what you're saying. Okay, guys,
absolutely,
I got it.
Absolutely.
Okay, so the last piece of this is where the advice came to the and this is gonna be the last thing we talk about quickly, and then we leave. So the quicker we can run through this, we get out of here. So it says the conviction before the court in Exhibit CAF2, which is the tape, right, took place in the last few weeks or months, long after the court had made a determination on the prima facie evidence that all the accused persons had a case to answer. And the first accused, so a 5-year following and reading from 37 all the way down. The last paragraph of 37. And it says, the first accused applicant had even mounted, the first accused / applicant had even mounted a spirited defense and closed his case. Okay, and then it says A3 is yet to conclude his evidence because there were issues with filing of his witness statement and case management, as is borne out by the record. In the circumstances of this case, and having in mind the issues at stake at the trial, being ambulance that all parties acknowledged are of no use in the conditions that they were delivered in, the circumstances and justification of which is the subject of the instant trial, and how far this case had traveled before the conversation that sparked this application came to be, I should think not. Based on Exhibit CAF2, the Attorney General is heard speaking to the third accused person he is prosecuting outside the court and discussing the evidence, and even making suggestions as to what the accused should do to obtain an adjournment. That, to my mind, may negate the principles of right thoughts. That said, however, the third accused cannot, by any stretch of imagination, be seen to be the one to be procuring new evidence or cowed by the conversation. But the whole situation could be a source of discomfort or discomfiture. I have found SAPRA on well-established principle that is well benign, impossible to injunct a statutory body or public officer from carrying out official duties. I have also found that the circumstances of this case to not merit a termination of the proceedings to its logical conclusion. However, to prevent further, so here's the key things here. However, to prevent further erosion of the judiciary process is very instructive. If the judiciary process was now already eroded, then the use of the word further there would be unnecessary. So it is that this judge believes that what has been heard on that tape eroded the judiciary process in a way. That is why she's using the word further. I just wanted to kind of point to that and then conclude by finishing this reading that it says, however, to prevent further erosion of the judicial process and uphold the principles of justice, judicial notice having been taken of what public controversy this may have generated, I am of the conceded view that it would be prudent, underline the word prudent, that the Attorney General be strongly advised, underline the word strongly advised, not to directly or personally involve, not to be directly or personally involved in further prosecution of this case. This is not in any way, shape, or form making a value judgment on whether the Attorney General was right or wrong in holding a conversation bordering on what was a live case in court with an accused person he was prosecuting. But I am of the respectful view that this is one way of ensuring that the judicial process is protected and to gain public confidence such that it may not be the perception that the case can be dealt with in any other place than the courtroom. So the judge is worried about the perception that is created out there that the judicial system couldn't be trusted. The judge has recognized that these conversations are already kind of impacted delivery of justice in a way, and she's saying that it is prudent for the Attorney General to stay away. And she's actually couching this advice as strongly. This is not, I just advise you, this is not, well, it's not an order, but I think this is the judge being respectful of the office of Attorney General without coming out to say, I ordered you. So you remember in our platform, when I was reading this, I told you guys that the judge just politely ordered this guy to get away from the case. But what have we seen? We've seen the Attorney General came out to say that he's ignoring the prudential advice given to him by the courts. Advice which was not only given, but was strongly given. And there were reasons for that advice. The reasons were that he has already prejudiced the process, and we are trying to prevent him from further prejudicing the process. Second, that the perception of the public that they can use other means of getting justice other than the courtroom will be impacted if this guy didn't step down from this case. But this guy came out defiant. Is it, appropriate for Attorney General to take the positions that he is taking after a prudential advice from an appeals court judge to him, advising him of the impact he's having on the legal process and the perception of the people? Because people conduct mob attacks in our country, killing other people on the belief that they don't believe they can get justice in the courtroom. And that is the concern of the court. Do you think his defiance is an affront to everybody and this guy should actually be fired? That's to you.
Oh, media, it's pretty simple. My answer is simple in this case. So the advice was good, it was okay. What occasioned what happened was something very unfortunate. He trusted somebody and the person recorded him and tried to give a different meaning into it. They were not able to establish that the whole point is that it is not a case of I asked you to do. I have closed my case. What did you do to aid me? You couldn't go into all that. So it is just, at the end of the day, everything points to, you may say it is inappropriate or whatever you want to put it and stuff like that. But, as you can see, various opinion on that. I don't think this is something that constitutes something that should result in a resignation or being fired and stuff like that. And that's not going to happen today.
Yeah, the thing is, he single-handedly has, what the judge is pointing to him, and I can read that part again, right? He said, the judge says, I'm of the respected view that this is one way of ensuring that the judicial, okay, this guy's trying to come on, but okay, let me finish this. He says, I'm of the respected view that this is one way of ensuring that the judicial process is protected. Okay? You wouldn't even go far to say you are trying to ensure that the judicial process is protected if you don't think it's not currently protected because of the actions of one single man. And you are saying, and she went on to say that
it is because out there, babies with sharp teeth has portrayed a certain narrative out there.
It's getting out there. It's what was done. I mean, don't blame the messenger, right? Blame what actually occurred. This guy was the one. Nobody forced him to go.
Okay, what occurred? Why don't you send it to court? Why you hold a press conference on it to
Well,
portray
it was sent to
and
court.
to narrate it in a particular way to people, to the point
Like
where you were called. You were called the next day and you warned that, hey, when you come to court, make sure you situate what happens in
But
court
the
and
thing
report accurately. Now,
I felt like I
the
was
court
telling
gave
you the other
advice.
day.
Somebody said the court was directed. You know, somebody is out there, you know, using words that do not reflect what actually happened. So, you know, so in the court of public opinion, there's a perception that is created.
But for the Attorney General making those comments, nothing would have gone into the.
It's not obliged though. So if the Attorney General disobey the advice, it is not illegal.
You got to look for
appropriate. It is within his rights.
So what the judge is saying, I'm just kind of bouncing off what the judge is saying, right? So the judge is saying the judge has done. How many times did she say she listened to this? 10 times, more than I have listened to.
Yeah.
So after her 10 times, this is her judicial conclusion, right?
Yeah.
And she's saying that, you know, in her respected view, that telling the Attorney General to pull away from the case is one way of ensuring that the judicial process is protected and to gain the public confidence such that it may not be perceived, it may not be the perception that cases can be dealt with in any other place other than in the courtroom. So basically, that language there, that cases can be dealt with.
There's not a single case that has been done anywhere apart from the courtroom.
What you're not hearing in that submission is that people take matters into their own hands. We are having mob attacks. So a person who is listening to this, who has a case in front of the court to say, oh, somebody raped my daughter, so I want to take the person to court, knowing the prosecution can kind of do all these things, I want to go find the guy who raped my daughter and take care of him.
No, it's not true. That is me dealing with the case mob attack.
But I'm saying that is me dealing with the case outside of courts, which the judge in her judicial reasoning is thinking is not the right way to deal with these things. And
we disagree, and the Attorney General disagree, and that's fine.
The Attorney General, you see, so the Attorney General's disagreement, it's again unprudent. That's what I'm saying, that perhaps he may need to be let go because he's been so defiant. I don't think, does he think that, is he the only lawyer in the Attorney General's office that can faithfully prosecute this case so that he will say he doesn't want to take himself away?
I mean, what you can, so here is the thing, and sometimes you don't have to overtake this.
No, it's a simple question. Is he the only one who can do the case in the Attorney General's office? He's not. He wasn't the one who filed the charge sheet.
If you are in a capacity to appoint
somebody different.
No, if you are in a capacity to appoint, maybe you will find someone else other than him.
No, but I'm saying there is a deputy prosecutor, the DPP. There's DPP there who was the one who actually.
No, there's a deputy attorney general before the DPP.
There's deputy attorney, but these things actually get prosecuted by the DPPs and their assistants and all that. They actually file the charge sheets and all these things. These are competent lawyers with experience in the department, spanning over several administrations.
Okay.
Can they not run this case without dummy presence? Can they not?
They can.
So what is Dummy's disrespect to the court when he was giving prudential advice? Disrespect. No, I mean, he was giving a prudential advice which was couched to be strongly advised.
It doesn't matter. It still remains an advice. It is not an order. Why do you want him to do the other one? But listen to what the judge said. Okay, he can obey or not obey. So why do you think that he must obey and not obey?
He must obey because of the grounds that the judge was using. The judge is saying that to stop any further erosion of the judicial process, meaning that he has already eroded the judicial process by his conduct in a way. You know,
that's what the judge thinks, and some of us disagree with that position.
Well, whatever the judge thinks is, because if you disagree with that, then all the things we disagree with this should be thrown away. But the point is, we don't.
No, you don't throw it away. You are okay to take a position. But the Attorney General went there
in his disagreement to tell the public that I'm not going anywhere.
Oh no, Onka so Ethiopia, and then it belongs to someone else. Onka won't you?
What did he say?
Onka won't Ethiopia. What's that say?
Last time we can hear you.
Your Bebeko officer.
We cannot hear you.
Propaganda. It is okay. Lifetime we can hear you. You see, let's understand basic stuff, okay?
Add your last closing comments to that so that we can go.
Yeah. In my last closing comment, I want to tell.
Oh, we just lost a fat too. Lifetime, can we hear you? Are you?
Oh.
We lost a fast. Lifetime, I think I can hear you now. Say something.
Calling.
No, I cannot hear you no more, my brother. You are off completely. So maybe go out and come back in. No, I can't hear you. I cannot hear you. So just go back out and come back in. So guys, as we wait to take the last words from our guest, I want to thank everybody who tuned in today to watch us and listen to us. Please subscribe to the channel. That is how we would actually grow and gain attention. These programs. Okay, FR.
Yeah.
So I was just
so
asking everybody.
Yeah.
Okay, no problem. I'm asking everybody to subscribe. So, so also ask them to subscribe, of course, so they can listen to you every day. The dedication you put to this program is beyond bounds. You are always here sharing your views, supporting your canvassing the position of your party. And so I want you to speak to your party, members who are watching you directly and solicit their subscription to our channel so we can grow and become powerful, strong.
I'll be sharing it to them. Yeah, my last comment. The comments that Lifetime made about if they boot for boot and all that, we don't need that in our politics. There is the registration and people are going to the stations with guns and knives and all that. With there, and then there are injuries. They're going to stop. Go and vote. Go and transfer your vote. Go and do this and go back home. What is this violence? We've been doing this for, how many years now? We got to grow. There's no point in, if somebody thinks he's more Ghanaian, who has gone to say he's more Ghanaian than you? At one point in time, there was the quality grain. You are looting the country. You think that people have taken all these millions away, money that could have been used for road construction or for schools or for hospitals. You think somebody can just sit in the comfort of their home because they got opportunity to be in government and just squander this money? Hell no. The good people of Ghana also need justice. The quality grain came. The National Communications Authorities came. The Sadinam Tamaklo. All these huge sums of money. And look at the circumstances under which they take all this money. You think the good people of Ghana don't need? These are the money that have led to all this colossal debt that we have to pay. And when people are called, you see, those days, when people were picked up, they were picked up in Rambo stars. We don't even have them. You got invited. We've gone far in the way we handle our citizens. We've gone far. Go to the court. If you have a case, go and challenge it. You don't agree?
But here is the case: the Attorney General is manipulating evidence against people in court.
You have not proved anything when
the judge is saying, "Hey, well, that's what we've been discussing."
The judge said, right? Don't forget, the judge said, "I've listened to it 10 times. At no point did I hear the Attorney General saying this and this and that."
And I think the judge is wrong. The judge is wrong on that. The judge doesn't need to hear
their claim came from the other side.
The judge didn't need to hear it from the Attorney General's mouth. As long as the Attorney General is on that call, when those comments were made about his engagement in trying to influence an evidence, and he didn't say anything. He did not influence
him.
Well, no. Look, if I came and say, hey, thanks for helping me go steal from the bank, and you didn't say anything.
There was nothing that the Attorney General did not say help me. In any case, the Attorney General said in the audio, I don't really need you to help me win this case.
No. He says, I don't need your help, right? I don't need your help.
I don't really need your help.
But you see, you have to interpret that. The Attorney General, but the same Attorney General on that tape to say, if you agree with this position, it wouldn't impact you in any way. So don't forget that the judge, for some reason,
that is subject to understanding.
The judge, for whatever reason, did not even mention that part.
No, that does not mean help my case. It's a discussion, right?
Okay,
a chunk of the discussion was bordered on understanding of LC and when it's issued.
Yeah, but I'm saying
A
that,
chunk
right?
of the discussion.
But I'm saying that the understanding the Attorney General wanted from the accused person, right, is on a factual matter, which the accused person is part of. So this is something the accused person have a personal knowledge of. That is why he's being accused. That's why he's mounting the witness box to testify. You cannot tell him to have a different understanding from the understanding that he has.
Yeah,
When you do
but,
that,
but,
you are tampering with the evidence. Hold on. Let me finish. Let me finish. Let me finish. When you do that,
I thought you said we are done.
Yeah, but you raising some issues that need clarity, right? If you go to tell a person who participated in an act to perceive it in a way different from the actual perception the person has of that act, you are tampering with evidence. But I'm saying
the judge is not saying what you are saying. The judge is not see it, and that is the person close to give judgment. So when the judgment has come, you cannot say, even though you have judged, I think you should have said it. No. You can say that, but at the end of the day, what she said is what we're going to go by.
Well, that is why I have a problem and it's subject to appeal, right? That's why I have a problem.
Listen. When a judgment is given, there's nothing wrong with having a problem with it.
Yeah, that's what I'm saying. That's what I'm saying. That right. If the judge was to be fair to all of us, right, he would have done an analysis of each of the statements, like sentence by sentence, and show us that because you can't just cherry pick what you say. Oh, this is what I've heard, and these are the things I heard from Jakpa, and that
so let us not act like it's words. Let us not act like it's here, right? And think that whatever the judge has said ends the matter. You still have layers. Actually, you have 3 layers more to go.
Okay.
So if you're not going to exhaust those layers, let's conclude on this and know that the application you filed has all been dismissed. Case closed.
No.
Dismissed.
Well, they've dismissed wrongly, right? And that's the point of this discussion. We've exposed because
the court knows that the court itself can be wrong. That's why we don't have just one court. We have layers. You've gone to the High Court.
Oh yeah, absolutely.
Right? There's the Appeal Court. There's the Supreme Court. And even at the Supreme Court, you can ask for a review. So
absolutely.
Other than that, your case has been dismissed.
Okay.
The advice the judge take, the Attorney General, respect the advice, but will not take it. And there and then, in fact, after the judgment, he went on to adjudicate, to go through this thing. So, I mean, we can, until we...
So you are saying that where a sitting judge observe an erosion in the judicial process and strongly advise the Attorney General as an individual, not the whole office. She's not adjuncting the office from further prosecution. She's saying you as an individual who, as a practicing lawyer, engage in this act, I'm strongly advising you to step away because your continual participation is likely to prejudice the case and cause the public to have confidence issues in bringing cases to courts. And you are telling me that the Attorney General telling the judge, I don't care. It's fair. It's a way that we want to.
So you disagree. You see, the thing is, there were 5 applications. You disagree.
I'm not going to through the whole 5. I'm asking you that, and an advice was strongly given to the judge.
You disagree with the judge on certain portions and agree with her on certain portions. Me, on certain portions, I agree with her. On certain portions, I disagree with her. These are opinions outside of what we have. Okay, it is advice. It may be strong, unambiguous, unprecedented, whatever. Let us use all the accolades to describe the description to describe the advice, right?
What I'm trying to point to you is that, right?
It is just one word, advice.
What I'm trying to point to you is that, right? If the judge have these feelings that there is a strong erosion of the judicial process, isn't it counter to her disapproval of the Mistrial application? Because the Mistrial application is based on the fact that we thought there's a failure to observe natural justice, right? If the judge is not warning the Attorney General to stay away because of further eroding the process, shouldn't the already eroded judicial process be a grounds for actually granting a mistrial or a retrial, so that the evidence are cast in the proper manner? Because it appears that Attorney General is not casting the evidence the way it's supposed to.
No.
Anyway, okay. So let's also take final words from my brother, right? Sorry, I argued with you through your final words, but
no, it's okay. It's okay. I'm enjoying it too. I like the banter.
All right,
This
Mr. Lifetime Legacy, give us your last. We cannot hear you. You need to go.
Man, you need to check. Let's draw conclusions, man.
Okay.
See?
All right.
You see?
Live, we cannot hear you. We cannot hear you.
We can hear you. We can hear you. Take off the glasses. Take off the glasses. Take it off.
Is he speaking with his eyes? All right, we can hear you Lifetime. Okay, guys. So I think we should bring the program to an end. This has been a very fruitful conversation. Afar, you wanted to talk to your MPP people, please use the opportunity to do so. If we can hear Lifetime, check your radio as Afar is doing his solicitation, and then come back. So Afar, take it over.
Yeah. Okay. So everybody that is watching, this is a great show. We come here to debate and contribute to the development of Ghana. We are all over the place on all the handles. Watch us, subscribe, critique us. You know, you agree, you disagree, you don't like what Ifa is doing, you don't like what Amuzu is doing. Put it all in there. Here we tolerate. We are not going to come to your house and punch you. We're not going to ambush you or do anything. You say, I say, and then at the end of the day, we are on there, we go. If you want to join us here too, you know, you are welcome. I mean, but subject to the acceptance by the man in charge of the seat, because he determines it. Some of us, we are privileged that, you know, even though sometimes we go banter, he likes our argument that we come here and share our views and stuff like that. So everybody should come, critique us, you know, join, share the feed and stuff like that. And together we'll make sure that you come here and enjoy a good show. Thank you very much.
All right, the discussions continue on the platform. So even if this show is over, this is not the end. We continue to argue. We are just addicted. So we continue to argue on our platform, the Ghana Agenda platform.
Come on our platform and see the thesis that Amuzu will be writing.
Yeah, they always today they were actually correcting my English and all that, which I love. You know? So, again, yeah.
Okay.
Laptop, we cannot hear you still, my
man.
brother.
Man, today is not your day.
Yeah,
type it in the chat. Type it in the chat. We can hear you.
If you type something in the chat, I can read it out. Yeah. Okay, so as we wait for Lifetime to kind of type whatever his last comments are on the chat, guys, if you're watching, please send us your comments, because we love to read your comments. I think I have one earlier, and what it says was that the question. Okay, Lifestyle say I have not. You have not admitted me. No, Lifetime you admitted, so you should be in. If you're not admitted, we couldn't see you. We can see you, so you admitted. So the question is from Kojo Do. He says Kojo Day. So he says the question every Ghanaian should ask is: the ambulance imported by the NDC was fit for purpose? That is the heart of the matter. Okay, so I guess Kojo is asking whether the ambulance were fit for purpose. But, you know, so I guess the clarification for that is, you know, the ambulances have two components, right? There is the vehicle. No, Lifetime, you are in. We can see you, so you are in. If you were not in, you wouldn't be on. So Lifetime is saying that I've not admitted him to studio, but you are in the studio. That's why we can see you.
The minister of health at that time said the ambulances were not ambulance. It could not convey human beings. It was not made to.
Yeah, and we understand that, right? I think there's an explanation for that, being that even if you look at, you know, the payments that, you know, there was almost a 1.5 million in letter of credit that was not disbursed, right? And that was supposed to go for the equipment. So there is two components to the ambulance. There is the vehicle, and then there is the equipage. The equipment.
But why that though? You go this and then you come later. We were told that the equipments were there, they were stolen and all that. You know,
well. So, but that has nothing to do with whether somebody has an authority to procure, to issue. So those are different matters, right? And you know, as the goods come to Ghana, inspection and acceptance is a different matter. You're supposed to do the inspection. There was no
pre-inspection. Pre-inspection was not done.
Well, so those would be evidentiary matters.
Pre-shipment inspection was not done, which was part of the contract.
So that would have been that would be a matter of evidence that perhaps has been submitted in the case. We'll get a ruling on that. But the point is that even post-delivery inspection is important, and then accepting of the goods, because once post-delivery is done, inspection is done, whatever quantity is rejected because they are not fit has to be subtracted from the contract, right? The contractor has to find.
It didn't say some of the ambulances. It said the ambulances that were shipped in were not fit for purpose.
But even if the ambulances were not fit for purpose, there would be a provision in the contract for the contractor to cure any defects. So until you exhaust those provisions, you couldn't come to court and say somebody caused financial loss to the state.
You caused financial loss.
How did he cause financial loss?
Let me tell you, there is the design. Now you're gonna tell them there's a design inspection. The manufacturing, after the manufacturing, and then when you finish manufacturing and you are putting it in the ship, they come and pre-shipment. You've loaded on the ship. They inspect when you get to the port. So all these inspections were not done. So who was writing what?
But I'm saying that, right? So when you have a contract,
let us not justify all these things. Everything points to the fact that somebody was doing something.
I think you should tell me.
They write contracts and then we go. You see, the politicians in Ghana, the politicians in Africa are inwardly corrupt. So when you get them like this, put them behind bars. We don't have to support these things at all.
Okay.
We talk about corruption because it's here. When they get them and they send them to court, let MPP get out of power. Let them send the minister to. You think I'm going to say no, you haven't done it. Go and answer. Go and answer. We told them in 2008 and 2010. MPP will talk. Go and answer. They went to court. They answered. As for you, no, they have not done anything wrong. No.
Okay, let us see. I've seen what you posted.
They have done something wrong. Go and
but we'll find a way to
prove your case.
No, so what I'm saying is that, right? These are contractual matters, right? In a matter of contract, if there is a provision for how a provider of services or products is to cure any defect in the product delivery, that need to be exhausted before we can come to the issue of causing financial loss. You couldn't just jump to say somebody caused a financial loss when you haven't exhausted the provisions in the contract that would, guide how defects are corrected. So in this particular case, Jakpa is even arguing this in his defense that there were provisions that provide guidelines as to curing this defect, and some of those defects were in the process of being corrected. But the government, because it's bent on bringing a financial loss case, did not want to partake in, taking those equipments and equipping the ambulance to get it to a usable state. Of course, a two-component delivery of ambulance and equipment cannot be construed to be complete when only the vehicles are delivered. There has to be the equipment and they have to be installed for an ambulance to come into assistance. Anyway, on that note, Legacy, I have received your message about you not being admitted, even though I feel like we can see you there there's no other thing for me to press at the moment to bring you in. So what I would do is check what could be causing that so that in the future we wouldn't have that issue. Thanks for coming in. Thanks everybody for watching the show. My name is Alfred Amuzu, and today has been fantastic. We went into all the details. We've exhausted this one. So if there are any questions again coming up from the courts, maybe next week we'll come back to it. Otherwise, we'll find other useful things to talk about. I know there is the contract with for the internet thing, the Wi-Fi that, of course, is getting a lot of attention. That's an interesting one to would like to take up in the future. I bet any new developments coming within the week. On that note, I thank you so much for watching. And, if this Saturday is Ghana Agenda, please share the word. Tell a friend to tell a friend. My name is Alfred Amuzu. We will be back next week to continue. Have a good day. Bye-bye.